I mean, your speaker. Turn your speaker off.
Yeah, there's no code that's taking mute because you're.
Because we're gonna get feedback. So your volume, your system volume. That's why I was
Well,
messing with that.
yes.
I was waiting for that.
I know.
Yeah, there we go. Okay, great. Okay, now let me turn mine on.
No. Well, it's just
And
weird just
everything should be
going through
okay.
Employees in my section and figuring out who's gonna be
Okay.
in office, who's not gonna be in office.
Blake, can you hear us okay?
I mean, before.
Okay, we can't hear you.
Oh,
You're
he's
muted.
Because I'm muted. I apologize, I was muted, but yes, I can hear you.
Great.
I think that
Everybody's
probably
here.
sounds like
Everybody's here.
Start.
Okay, I think we have a quorum. Order. So this is the State Records Committee. Today's date is June 10th, 2021. And the first item on the agenda, I think maybe we should do introductions, at least of the committee, since we're in person for the first time. So Tom, will start with you.
I'm Tom Harrelson. I'm the media representative.
Marie Cornwall, citizen representative.
Ken Williams, I'm the state archivist.
Nancy Dean, the political subdivision representative.
Mark Buchanan,
Oh, I forgot that.
records management.
Private sector
sector, right.
records manager. Yeah, that's right. Thanks, Mark.
And I'm gonna make a suggestion right now, since the owl's way out over there, try to speak up if you're saying something, because the people on the screen might not hear you very well.
And
So
we can move it closer.
speak up, project,
What do you want?
you go quiet,
That's-
not as good. And we're gonna look at the beady eyes of the owl.
I know, like,
It's like having a meeting at Tracy Aviary.
It is.
I'm
oh, we like that view.
do a blinking contest, I'm gonna lose.
Yeah. They can change the view.
It'll follow you.
Not me and Mark.
So the first item on the agenda is Thatcher versus UDOT, and this was a continuance and it's a report that's required. So we will, I guess, go to the requester first.
Thank you very much. I appreciate your time and appreciate the opportunity to appear via Zoom still. The update at this point is that we have received what UDOT has said is all of the records that they are going to produce. They are going to provide us notice of the records that they did not produce and the designation of why. And then I think we're going to need to do some work with respect to potential mediation with Rosemary. And so I'd ask for this to be continued for just one more month. And hopefully we'll be at that point, know where we are with mediation and know if we're completed with the process.
Thank you, Blake. Mark.
That's fair. That's exactly where we are. UDOT's produced many thousands of records. I'm in the process of, I hope to report today that I had completed all my productions and provided Mr. Hamilton with my Section 205 notice indicating what had been withheld and the legal reasons for that. And despite my best efforts, I was not able to get that done by today. I think it would be productive to work with Ms. Gundit to the extent that we're producing records that a petitioner thinks are beyond the scope or attachments that can't be opened. And I think all that can be handled in the ordinary course of things. And we'll report back next month.
So, Paul,
Yes,
a continuation is in order, correct?
if you would like to have a continuation, you can have a motion for it and we'll be happy to do it. We've had great practice with this.
So any comments or questions from the committee?
I just appreciate, oh, sorry, I was just gonna say, I appreciate the parties working together and trying to resolve it.
Is there a good level of confidence that you might be able to get it completed?
Yes, it's been a process, and I think that our efforts to make sure we're not missing anything have probably created most of the delay here. In that, if T Group or Mr. Rosenstein was mentioned either in the body of an email or an attachment to an email, we produced it because it was regarding that person or that company. And sometimes when you get a large production of records and you get everything that's attached to that email, it's hard to figure out why that record was produced. And I think those are the kinds of things that we'll be working through. But I can verify to Mr. Hamilton that everything that we have produced references either Mr. Rosenstein or T Group. somewhere, either in the main message or the attachment to it. And he had indicated that he had seen some duplication, and part of that's because we were picking up both the sender and the recipient's communications. This record set was produced through a search by the Department of Technology Services, through named people and named email addresses. We've uploaded it to a document analysis system, and we've gone through record by record to make sure it's within the scope. We have had some records that were gathered that were outside the scope. For example, records that mentioned the two entities, but after the request was received, for example. And so that would not be within the scope of what they've asked for because it was after the request came in. So anyway, that's where we are. And I am hopeful we can get it done. My obligation is to produce what I know I can produce and give Mr. Hamilton a reasonable estimate as to how much longer it's going to take. And I'll work with him on that as we work with this.
Thank you. Any other questions? Motion?
I would move to continue this hearing until our next meeting, July 8th.
That's the correct date. Rebecca? Okay.
Is that what room wise?
Huh?
Do you have room for that?
No, but if you've seen that, no.
That's what I was thinking. That's at least the intent.
Right. Hopefully, it doesn't need to be, or they can resolve it, then it's okay if it's scheduled that day, right?
If I can just add one more thing too. Hopefully the process of working with these people, there will be an index of what has not been produced, and we can, for example, attorney communications, maybe we can eliminate that from whatever camera review might be necessary. I don't know if that will be ready to develop that additional access to site on.
We have a motion from Nancy.
I'll second the motion.
And a second from Tom. All in favor of the continuation, please say aye.
Aye.
Aye. The voting is unanimous.
Thank you very much.
Thanks, Blake.
Thanks.
So that might be the record for the quickest.
We're trying.
We're really trying hard. We really appreciate it. So we're going to move on to business since we're ahead of schedule and things are moving right along. So the first item of business is the approval of the April 29th minutes. Does anyone have any input, questions, changes? A motion?
I'd move to approve the minutes from April 29th, 2021 as written.
A motion for Nancy
Second.
and a second for Mark. So all those in favor of approving the minutes of April 29th, 2021 SRC, say aye.
Aye.
Aye. Any opposed?
Oh, you know what? I should have abstained. That was the second meeting in April. So Tom abstains.
So Mark, Nancy, Ken, and Marie vote yes, and Tom abstains because he's not present at that. Next on the agenda is the administrative rules update. It's
Yes,
going to be
we
given
have
by Rebecca.
in the business folder. We have just a couple edits to R35-1-2. Line 2 has an edit so that it adds a sentence that says presentation shall be limited to record access and unreasonable denials of requests for fee waivers. That's just to have the tool if necessary to get off of the topic of procedure that the committee can't really do anything about. There's another edit. I thought, or was it just that one? That's the only one I see.
B,
Yeah,
5B,
letting you destroy them.
or destroyed.
For the in-camera records, Rebecca.
You just added the words or destroyed.
Right. I'm trying to find the underlying thing, I'm not seeing it. Where is that in? I'm not seeing it in the document.
5B.
She's using my
Yeah.
computer, so
Or destroyed.
it's all,
What we're looking for.
Yeah, she just added, I think she just added the word or destroyed.
Yes. And so if the committee approves these changes, then we'll work with Kendra to get them submitted to administrative rules for public input and bring any input that comes in back to the committee.
Can I make go back to two? And this may be, I'm just wondering if we ought to say something about being responsive to the Utah code, not only limited to records access and unreasonable denials of requests. I don't know what the language would be, but something about referencing the code, because
We
is
can
that
only
too
make
much?
rules that fit under the committee's part of the code. I don't know if that addresses your question.
Well, the only reason I'm raising it is that people who understand the records committee would understand what that means. People are doing it for the first time, they not. And maybe we can't address it, but what I'm trying to think about is how to cue people in that we don't, that the issue isn't one of, well, I don't know how to, I mean, we get people who come in here and argue the case and never mention the, the code.
If you'd like, I could put in a scheduling letter to say, according to this part of our administrative rules, please keep your presentation to the matter, the subject of record access and denial.
Oh, that, yeah.
So then
that
it's in
would-
the letter.
Oh, that'd be fine. Yeah,
do
that'd
that.
be good.
In a way, it kind of tells them what we can and can't do.
Yeah,
So they may not know anything about the SRC and what, what they think. we can
right.
do.
And then the letter would address it better than sort of,
Then reading.
than reading, trying to understand it here. That resolves my concerns.
So just to be clear, so that's the letter that's going from
From
the
me, when the
correspondence
appeal
with
is
the
scheduled,
back and forth between the requester and the secretary,
right,
scheduling.
to the requester and the respondent. It just says, make sure you send stuff to the other party and you have this, you have to have everything into the committee by this date, and so I'll put that in there too. So everything they need is in the letter.
Yeah. I
All
think so.
those comments.
Yeah.
I just think just considering the number of pro se people, that's probably a great idea. Again, the more information they have, so they can prepare, because their first reaction is probably not going to be to go to the administrative code. But when they get a letter, and they'll probably read through it completely, that can help them.
Yeah, I agree. That's a good idea.
Thank you.
Mhm.
So.
You need a
any-
motion to approve those edits?
So were there any comments on the second request on the return of the in-camera records or destroyed? Everybody okay with that suggestion? All I think we work with you on that. So I think legally we're in good standing.
Yes.
Thank you.
Rebecca, are there people who say you can just destroy them and they don't want them back? Is that?
They usually don't say anything.
But Tom,
But,
if I'm remembering correctly, we've had a request for those records to
right,
the committee.
Oh, I
And
get you.
we
That's-
never take possession.
Right,
of
I got you.
Only for the
You're right.
in-camera review. And
And basically by putting in administrative rules, we kind of get away from that whole thing, because they say, well, if you have the records, therefore you should possess them.
Right.
And they try to get around getting it from the government by getting it from us, and we just don't want to be involved in that. That's what.
So we just wanted to be clear that the secretary handles that after the in-camera review, they're returned, or if the agency asks us, we'll destroy them. We were concerned, we want them to tell us to destroy them.
Mhm.
Because in times past, past, sometimes that's the only copy. And we want to make sure that we're not destroying records that shouldn't be.
That would be a bad thing.
That would be terrible.
The chief archivist for the state would be very upset at that.
And probably subject to fine, right?
Probably.
We don't want that to happen.
I'd have to prosecute it, so no, I don't want to do it.
Oh, man, I don't ever want to be
And I'd
on the
have to-
receiving end of
And I'd have to
the call.
report it, so there you go.
Do we need to put something in the rules about we only destroy it with permission from the entity?
So we talked about that a little bit. Rebecca, do you recall the conversation that destroy it with permission or by request? I'm not
Say again?
remembering.
So after the words or destroyed, should we put something that says, per request or with
No,
permission?
that's just part of the process because we put them on the drive and then we destroy them. We don't return them. So it's not with permission. It's,
You just do it.
we just do that. So we don't have it on our drive.
I guess to Mark's comment, you're getting at, is the agency okay with us destroying?
Right.
Um,
Because you said that we didn't destroy them unless we had their permission. I thought that was what you were saying.
We
If they
always
give us
check-
a copy, we don't destroy it without their permission. But if they send us a digital copy, it's an extra copy, right? They have the record copy.
That makes sense.
Thanks for clarifying. Any other comments on the rule changes?
One that I just thought of, and I don't remember if we talked about this last time. Petitioners can also appeal a claim of extraordinary circumstances. Do we need to add that on 2? Presentation shall be limited to record access and unreasonable denials. Does that address
That'd be
the claim
under
of extraordinary
records access. Yeah. They're not getting access to the record because they're claiming extraordinary circumstances, so
Okay.
we're fine.
Any other comments or input? So,
Oh,
go ahead, Marie.
I'm sorry, this isn't related to, except that it says in here 20 minutes. Didn't we talk about trying to give us more leeway to reduce the time?
We've talked about that before.
And do we want to do that now, or we just, if someone decided we're just gonna leave it at 20?
We talked about adding 2 words to say, so it says each party shall be allowed up to 20 minutes. We could do that. Then it's up to the chair, I guess.
Well, we're allowing them 20 minutes. We're not gonna
Right.
say, we can do it up to 20 minutes, we're gonna give you 10. I mean,
Right.
I mean, when the chair says you get up to 20 minutes, but we're allowing them 20 minutes. But if he says up to 20 minutes is better than if you stick an administrative rule. Because that makes it sound like we can arbitrarily say, well, we can give you up to 20 minutes, but we're gonna give you 1.
Because it's the way we feel.
Because of who you
Yeah.
are, we'll give
Yeah,
you
because where
5.
you are, you've been here before, we don't like it, no, we don't want to do that, so I think an administrative rule, because you're delineating what the requirements are, you get 20 minutes, but then when you introduce and say up to, but in the rule, if you say up to, it sounds like we have the ability to change it.
I get it.
Oh, okay.
So it just, it still allows us to drop it if we're busy?
Well, allows them to take less time, but we should give them 20 minutes.
Oh, okay.
Yeah,
My understanding was it was parties getting off topic that was the frustration, not necessarily the 20-minute time. And so hopefully this edit will address
Oh, I see what
that
you're
concern.
saying.
I don't think we've had a situation where we started limiting parties' time because we had a schedule that was tight.
Yeah.
I think if anything, we just kind of encourage them to say, we've got 8 hearings today. We would appreciate it if you take less than 20 minutes. Just understand we've read through everything. But I don't think we've actually gone through and said, we're going to give you each 10 minutes each.
Okay,
I mean, that could be a problem.
we can use a buzzer if they get off.
I'm waiting for the red light. We tried the red light. It helped a little bit. Just-
That's right. we
Well, it
used
was
to-
working when it was on WebEx. If they knew, show what time is good
Yeah.
that last something.
But I agree with Paul. I think it comes back to the chair, like running the meeting a little tighter. And I was hoping to, you guys say can't tighten it up. So.
Okay.
happy with that.
Just
But
remember, Holly
Rebecca, do
had
we
the
have it in the, like, the chair material? We have the meeting guide, running the meeting guide. We could add something there for future chairs. watch the time.
I don't think we've had too many respondents or petitioners that have tried to go over that 20 minutes. I mean,
Just a couple.
yeah, I think sometimes we've gotten off on our time in our deliberations, but I think that's appropriate.
Yeah, I think
Yeah, we're the problem.
Well, yeah, I mean, think of that April 29th meeting, right? Those
Yeah.
were some really tough
Yeah.
things to talk through and took us a while to do. So
that's the one thing.
I like
you know,
it.
as chair, sometimes you're thinking, you need to give them a little more time than 20 minutes because it's a really difficult,
yeah,
Yeah.
and the discussion's good.
Yeah.
And it's in a way fair to both parties.
Yeah.
So, they're all great comments. Any other comments specific to the rule changes? So Rebecca, the process again would be to take comments today, then work with
Kendra.
with Kendra Yates
Okay.
through the rulemaking process. Then they'll come back after public comment. And the committee will have another chance to look at the changes.
Yeah, if there is no public comment, then it just gets approved, right?
So we need a report back, I guess, in the next business portion of the next hearing, where we're at in the process. Okay.
you need a motion.
We don't need a motion for it, do we?
I thought it was motion to approve the changes.
thought there was a motion made.
I think we just need to
I
vote.
mean,
Wasn't
I
there?
don't have down anyone.
yeah.
Okay. Nancy, you got the record
Hey, I
today.
am not doing all the motions today, so I'm gonna do this one, and you guys need to remember that the next two are somebody else's. I move to approve the amendments to the, do I need to say exactly which rule? I clicked off of that page. The proposed amendments for R35-1 and to send those to Kendra to get them into the process. I don't know what that motion needs to say, but
Just the rulemaking process.
yeah, the rulemaking process.
I'll second that.
Okay, we have a motion by Nancy to approve the changes and a second by Marie. All those in favor, say aye.
Aye.
Anyone opposed? Okay. Motion carries. Moving right along. So SRC appeals received and declined notice of compliance and related action items.
Okay, we have a lot happening here. I'm going to share my screen. Okay, I have 2 appeals in my inbox that will be scheduled for September, but I've really tried not going to September until I had to, so we're going into September now. But
Oh, my goodness.
for this month, I did get one incomplete appeal from an inmate. I don't have the initial request. I don't have anything. I'm not even certain he came to the right person. And so I sent him back a letter, and so we'll see if that comes back. Brady Eames versus State Treasurer was denied because the records do not exist. He had submitted a request for about 8 different things, requesting an oath of office for the interim, I guess he is, state treasurer. The state treasurer resigned, right? Got a job somewhere.
It's for first thoughts.
And so it's for Kurt Slaw's oath of office, but he hadn't actually been appointed as state treasurer yet. And so they explained the process to him and said they don't have any records. And so that appeal has been denied. Henry Hopkins versus Corrections. This one was denied because of a previous order. And George Ross versus Corrections was denied for the same reason. They were both asking for policies and procedures, and the committee has heard that several times, it feels like. And then we've had 1, 2, 3, 4, 5, 7 appeals withdraw. And we got a few more that I'm expecting will be withdrawing soon.
So Rebecca, on the,
Huh?
those that have withdrawn, is that because they had received the records?
It was resolved in mediations. I assume they received the records. A couple of them with Sam Stecklow, I think those with post were resolved as a result of the committee's decision with the other ones that he had with law enforcement.
So that's what, you know, an example of having a really full agenda. And the ombudsman has been working with the agencies, so all those withdrawals are the
Yeah.
ombudsman working.
Yeah,
Yeah.
we had
Thank
some
you.
that have been mediating. There's some parties that had a meeting yesterday and it's working, they're working hard. And then with the April 29th meeting, we have received the notice of compliance from Salt Lake City Police, and I just got one this morning for the other case with the Salt Lake City Review Board. We got a notice of compliance from those and a notice of intent from all the others.
Really?
Yeah, and so
How many others?
West Jordan, Cottonwood Heights, and Washington County Sheriff. So 3. And I received a summons for Washington County, but I'm gonna leave all that stuff to call.
Take your time, by the way. Take your time.
Take my time?
Yeah.
Okay. For August, so I schedule as many appeals as I can. I usually go up to 10 before I start going into the next month. And we've got 1, 2, 3, 4, 5 for Brady Eames in August. One of them with SWAP has kind of gone back and forth with whether or not they're a governmental entity. And that one ended up being scheduled because I can't tell if they're a governmental
So,
entity.
Rebecca,
So I decided the committee can take care of that.
So SWAP is a professional organization. that
It's a,
attorneys-
yeah, it's a statewide association of prosecutors and public defenders or something like that.
How are they governmental?
They answered his grammar request.
Oh, that was nice of them.
Well,
Did they understand it was, okay.
But that doesn't mean that, well, then why are we reviewing it if they answered? Oh, they answered,
Because
said
they
no.
answered saying that they denied the records. In another one, they answered saying they are not an entity, a governmental entity. And so I don't know.
Well,
So
but
it's
it-
coming to the committee.
It's just a professional organization, right?
Yeah, I mean, they're public employees that got together to have an organization. That doesn't make it governmental. I mean, unless it's being funded completely by some governmental entity. I mean, I'm trying to even think in terms of John Dougal. Would John Dougal go through and audit them? Of course he would. Okay.
State Archives has asked the auditor's office for it.
They said they'd get back
Okay.
to us.
My recommendation would be to wait to hear what the state auditor says, because the state auditor does not consider them a governmental entity. No one's going to consider them a governmental entity.
Didn't we
I
have
mean-
that with the Association of Counties too?
Yeah. Yeah,
And
same
we
thing.
decided they weren't, right?
Yep.
I can't remember what we decided.
Aren't they?
No,
They're not.
we decided.
They're not?
ULCT is though.
Okay, yeah, that's right.
Utah.
Yeah, it's confusing.
Yeah, but the
Because that one's
Association of
created
Counties is the
statutorily.
same thing.
I think we've had a couple of others too.
Yeah, some that we could maybe point
Yeah,
back
and
to
it-
if they give us the ruling that.
Paul,
They're
isn't
not.
some of the determination based on, are they using public funds for their membership?
Yes.
I think that's
Well,
one.
yeah, you gotta be careful with that. So an example would be the State Bar Association. So you have, State Bar Association has a whole bunch of governmental attorneys that all their fees are paid for by the governmental entities. But that doesn't convert the State Bar Association into a governmental entity simply because the funds are coming in. we're also kind of looking at things like, how are they created? Is it something statutory? Is something, is a governmental entity creating the organization? And here, I don't think the governmental entity creates that. I mean, they could, there could be, for some reason, Salt Lake County decides it wants to support every single prosecutor for the whole state, and they created the association. But if it's a private organization, even if there's public funds coming into it, doesn't necessarily mean it. It's a governmental entity. But the auditor, I mean, if he has a broad, expansive view of what is considered a governmental entity, and if he finds someone not to be a governmental entity, we can pretty much rely on that. The other association or the governmental entity we look at is the Division of Archives. The Division of Archives, if it's not doing anything with retention schedules, that's usually a pretty good indication they might not be a governmental entity. And I am guessing Archives does not have a retention schedule for them.
No.
No. So, so both Archives and the auditor come back. That's something I think state records when you get definitely rely on.
I think it's safe to say, because my records managers are in the room,
Yes.
that we initially thought that they are not a government entity, as the archives and records management. We reached out to the auditor's office to see if we could get other voices in determination.
So where's that determination from the auditor at? I mean, is that something that we would have fairly quickly?
I reached out to him with the last appeal that I received and just asked them what they think. And they told me they were working on it. And then my deadline to respond to the appeal was coming up, so I scheduled it. I have not followed up with them, so I can do that.
Because I
See
think
if they,
if that,
in the interim, they figured it out.
I'm just trying to figure out if there's a way that be obtained before we bring the parties in for that hearing, because, you know, they may end up coming here in July and finding, hey, we don't have any jurisdiction over this.
Yeah. Would I need a motion from the committee that if the auditor says they aren't an entity, that I send the parties a new letter saying we're denying the appeal because it's already scheduled?
I don't think you have to have the committee to go ahead and make that. I mean, that's more of a chair.
I mean, I have no problem writing a letter saying I was wrong.
But when we determine there's no I mean, with legal counsel and the chair and the executive secretary, if the three all agree that there's no jurisdiction, the committee has not had to meet on that. It will be reported upon the next time, but the executive secretary hears the appeal was denied. The committee has an opportunity to be able to bring it back in. But the executive secretary, the chair, and legal counsel have the ability to make that determination and then send a letter without having the committee vote on it.
You have those meetings for August, right? So you still got
Yeah,
some time.
Yeah. But, you know, maybe, we'll use Brigham Young as the example. Brigham Young determination was made by the three, and then that they are not a governmental entity in their police department. And then the committee had an opportunity to be able to take the case when it was reported upon. This appeal has been denied because found that there's no jurisdiction because they're a private university with a police department. We take it back, or just they get the opportunity to appeal in 30 days, in which case BYU, Salt Lake Tribune appealed that in 30 days. So they, and I just, in jurisdictional things like that, I hate to say this is probably better left to a trial court, district court to do, because then you're starting to get into the weeds of how's the funding, what is this, there's discovery process. I mean, BYU's case was months of discovery that took place, and for 20 minutes each side, we're not equipped for that.
So I'll follow up with the state auditor. And then outside of that, I think that's all I have, unless anyone has any questions.
And I just, I know we can't order, that's what I've learned, we can't order people to do anything, but tell the auditor that we're under the gun. We need that.
Yeah, absolutely.
If he's dragging his heels, tell me. I'll talk to John.
Okay.
And he owes me a few favors. So.
Okay.
The political arena.
He owes me.
Good, thank you, Rebecca. Any other questions for Rebecca? Okay, next on the agenda, cases of district court report.
No.
No?
Let's wait on that one.
I do have something else we could go over then.
Okay.
Yes.
I got a email and a phone call this morning from Mr. Stephen Pace, who requests the committee to reconsider his appeal. I have not looked at this email yet, but he apparently is confused about the response from the city. And I don't think we don't need to receive a notice of compliance or anything because the appeal was denied by the committee. Apparently, there's still correspondence going on parties' end, and he sent me along. I haven't gone over this yet. It's a couple pages long. But he would like the crux of it is he would like the committee to reconsider his appeal, and that's not something the committee really does. So I
We can
wasn't even
reconsider.
planning on bringing it up, but I'm filling time.
I'm sure we have other business, hopefully, but
We,
But we do not
anyway, so
reconsider,
it is,
period.
it's not uncommon for petitioners to ask for something to be reconsidered.
Do you respond to that, though? Just say no?
I usually say the proper process is to appeal to district court, but I usually get the request to reconsider after that 30 days has lapsed. It has not for this one yet. So I can let him know he can appeal. I'm always a bit lost what to say when the 30 days has lapsed. It's like there's this process, the committee can't really reconsider. I guess you can send a new request if you want. But then I don't really want to say that because I expect we would deny it because we've already heard it.
Right.
So,
And it's clear in your correspondence that they have 30 days. It's clear at the hearing.
Yeah.
yes, it's in the order.
Well, yeah, and it's state law. I mean, you could maybe point in your letter to the section of the code that.
I bet in the
Right.
letter.
Change the statute.
Yeah.
No authority.
I don't.
Paul, you keep having to jump in here.
I don't know if the committee has ever actually reconsidered an appeal. There's not really a process.
We've only
for it.
reconsidered that I'm aware of a denial of a hearing. and
Right.
More
Yes,
information
that's
became
different,
available. Committee,
And that's,
a committee member made a motion to reconsider the denial.
that's in statute.
It's in statute.
And we did that just a year ago.
We did that with
Okay.
Mr. Pace's
I was
appeal
gonna
initially,
say, his.
Oh.
his
Yeah,
initially,
which I think
yeah.
is why he's asking.
But we can do that.
Because it was
Oh.
initially denied and the committee looked at it and I didn't see an actual request for records in his appeal. And so the committee went through it and found one. So we changed the denial and scheduled it. So that might be why the petitioner feels like the committee can reconsider because they already have. So anyway, so we plan on just sending him an email to let him know what the appeal process is. See what happens from there.
Does council need more time?
Oh,
Okay.
it was a busy day yesterday.
So the last item on the business part of the agenda is the committee members' attendance poll for the next meeting, which is the 8th. 8th of July.
Yes,
We're in June already. Is everyone
Tricia
gonna
said
be
she will
here?
be here. Last time, she said she would be here on July 8th.
I won't be.
Yeah, so you're okay.
Yeah.
Good.
I'll be here.
We'll have a quorum.
Do we have any updates on our 7th person? Yeah, what's happening on that?
So we have been beating the bushes, getting applicants. We do have one applicant that's there for,
For the citizen representative.
so Tricia's term ends in September and she's not re-upping.
Oh, dear.
So we're looking for a
Who am I
citizen
gonna
member
argue
now.
Who's gonna make motions?
Yeah. And then, Paul, we have an opportunity to review some of our statute this year
Oh, good.
legislatively. So I'm glad you brought that up because I wanted to have a little bit of discussion about that position that we haven't been able to fill. Was when we created that, and that description, it was for somebody with database and electronic records management. That's what we were thinking. And we just haven't been able to get a pool of applicants to choose from. Back zero.
This is for the 7th position.
So Rebecca and I have been talking, I guess, Paul, we probably talked about it a little bit. Should we re-describe that position? Make it broader, and maybe encouraging.
Were the original descriptions, I mean, was that what was created when Brown was, or when the records committee was created, they had to have these criteria?
Yeah, but they've changed quite a bit over the years.
The last big modification was when we created the records management committee and pulled the approval of retention
Right.
schedules out of this committee. That was the last big update, and that's when we created that description for electronic records database.
Might just be too limited.
Well, and it also says in the statute that they are, what's the word? It's like the, Rebecca, do you have it handy? That they're pushed forward by an IT group, like an
It was
organization.
supposed to be the Technology Council
Yeah.
originally.
And when we were looking at that, there was a state technology council, and it had a lot of politicians on it, a lot of government people part of that group. Looking at their makeup now, there's no political folks, government folks in that technology council. And it looks like it's mostly private now. They're a big organization, but getting that recommendation from them proven futile.
And then Trish's is what, citizen?
Citizen.
Well, what other category would there be? Now, remind me, Mark, what is your category?
Private sector records.
Look at your,
Private sector.
Pull it
Yeah, I
up.
can't read it.
Way over there.
Way over
what am I?
there. Private sector records.
But Nancy's position, which is local government. And there's the League of Cities and Towns. There's multiple organizations that you belong to.
I mean, we used to have law
recommend
enforcement.
That local government. angle, but
Yeah, you did.
Which was nice for security for meetings. The
someone
county
in
sheriff
uniform.
here was, packing heat, so we felt very safe.
Yeah,
And that's what I'm hearing from the archive staff. It's like, well, maybe we should do law enforcement corrections.
oh, that's an idea.
Is one recommendation.
We could probably, I assume that we could put a couple options in the vacancy if we were to change it to say it's either a retired person from law enforcement or an HR representative or something that the committee deals with a lot. And then give it some options so we can get more applicants.
Yeah, actually, an HR person would be interesting to have.
We get a lot of stuff for law enforcement lately, but we have had appeals for disciplinary records, personnel.
Yeah.
Yeah.
Given the current climate, we're gonna get more from law enforcement, I think. So,
But the advantage there is that they have a pretty good knowledge of what should and shouldn't be released.
yeah,
The things they're dealing with, because seems to me we have an experience of a lot of people are coming to us, they probably always have for discovery. Some of it we quash, but still, I like that. And HR to some degree, same thing. Personnel records and files.
why don't we add two more members, one in HR, one in.
If we can enlarge the Supreme Court, we can put.
Yeah, that's right, let's pack the
Let's go for it.
committee.
Are you doing committee packing now? Is that?
And you get to pick a ball.
That is, I mean, that is, is that an option?
To expand the
We
committee,
could expand the
I think
committee.
that would have to be done, but.
I like the suggestion of maybe just broadening the description.
Yeah.
And I saw the chief records officer, Kendra Yates, nodding. Kendra, do you have any comments that you'd like to make?
I think that's a really good idea to not keep it so narrow. We had an empty seat for a long time.
Yeah.
Yeah.
Because it's so specific.
We had 2 empty seats for quite a while.
Just not necessary to be that specific in my.
That's the first time that's been a recommendation.
What would have, Paul, what, wouldn't that have to be?
Legislative.
Come from the legislature?
Yeah. Well, we're making statutory.
We can't get them to
Suggestion.
appoint seventh person, how are we going to add seats?
Well,
If the
you have
committee
to
wants
broaden
to
it
think
out.
about it for a while, the parties for the next hearing have a right.
So can we saunter?
Yes.
Rebecca, on the next agenda, though, I want to report back on the vacancies. You go off next.
October, a year from October, if they keep me that one.
When does my term expire? Because I'm just filling the previous.
I have a
Cindy?
post-it on my desk in the office.
That's fine. I don't need to know today. I just,
For you,
know.
your rest of Cindy's.
Yeah.
It's 4 years from when you started.
No, I'm filling
She's filling
Cindy's,
Cindy's.
She took the rest.
Oh, that's right.
so I'm different,
You
yeah.
might be eminent too.
Uh-oh.
You might be able to serve a total of 10 years.
No, I might be able to just serve it all.
Oh, we can't lose.
Paul's got the dates, I can see right now. No?
The Paul's still prepping.
Oh, okay.
I'm just teasing.
I am almost done.
Are you almost
I am
done?
almost done.
So
So the committee's gonna saunter? or
we
not?
will report back on that. Paul and I will report back on that because Paul works for, he's the counsel for archives. And he's also counsel for,
You name it. I'll probably
what's our new
represent
department? Government Operations Department.
Yes.
And
Yes.
so I have a meeting call with my director, executive director, and on Wednesday, so I'll bring that up with Jenny. And because right, it's a good time if we want to alter it. But it doesn't mean we couldn't fill it before the legislative session where that change is required. So we can still continue to try to get out there. We want to change. I really like that suggestion of broad administration. Shake some things loose, so we have a suggestion to saunter, and the parties for the next hearing are here,
Yes.
and that would put us a half hour ahead of schedule.
I'm
Which is
sending
clear.
my report to Rebecca right now, so I'll be good.
I can take it. Okay. Saunter,
Or,
5 minutes?
5 minutes.
okay.
So if you get lost
Bathroom break, basically.
on this floor, it's just a big loop.
Oh, okay.
You so just keep walking.
You keep walking till you find the bathroom, but then you can't find your way back.
Put on GPS.
Yeah. Did it go up? Oh, you are, okay, because for the saunter. Okay. All right.
Rebecca, if you stop the recording. Okay, we'll call the meeting back to order. So, Rebecca, are both parties online for this next hearing?
Yes, so we have the petitioner and Mark, I don't know how to say your last name.
Goodlick.
And Robert Payne is on for the respondent.
So this is Rob Sloman versus University of Utah?
Yes.
So
Yes, this is Robert Payne. Can you hear me all right?
Can.
Yes.
Great, thanks.
So, and welcome to the SRC. I just wanted to make sure and have you acknowledge, both parties acknowledge that under the Utah Mediation Act, any communication or mediation with the Government Records Ombudsman cannot be used in this appeal hearing. Can you acknowledge that?
We didn't mediate this, so.
Okay, great, thank you. So the way the proceedings work, or the hearing works, is that each party is allowed 20 minutes to make a presentation, and then there's opportunity for clarifying questions from the committee. And then each party is given 5 minutes closing statements. And so we start with the petitioner. So you have 20 minutes.
Thank you. My name is Mark Goodlick. I appreciate this opportunity to speak to you. I want to thank the Records Committee for taking time to hear the appeal. Also want to thank the university personnel for the work that you do on behalf of a publicly funded university and for taking the time to participate today. Nevertheless, this appeal is requested because a routine records request has evolved into a significant kerfuffle. We believe unnecessarily. One noteworthy reason for this evolving problem is revealed in the utter contempt and disrespectful light that the university casts on Mr. Sloman in its appeal brief. The university insults Mr. Sloman as not being deserving of equal attention because he is, quote, neither a member of the media nor the subject of the records request. I refer to paragraph 4 or page 4, paragraph 3. The university further clarifies this perspective by asserting that Mr. Sloman is engaged in nothing more than a time-consuming fishing expedition. That's page 5, last paragraph of the brief. And then in our last paragraph of page 8 on the brief, we see the university requesting that this committee summarily dismiss Mr. Sloman and this appeal on the implied basis, presumably, that the university is eminently reasonable and hardworking in its treatment of public records requests, and that Mr. Sloman is doing nothing more than pursuing requests and appeals that have no basis whatsoever and are frivolous appeals that interfere with and further delay the university's ability to fulfill grammar requests, including Mr. Sloman's. This is shameful behavior, and it's well beneath the status of a state institution. And with these attitudes, it's no wonder that the university struggles to clear its docket of public records requests. And for this alone, I ask the committee to join me in asking the university for an apology at its personal attacks against a member of the public. But let's move on to the substantive issues here. A second reason for this evolving records request problem is completely overlooked by the university in its appeal brief, not even mentioned. By this, I mean there's a key to unraveling this entire affair that was present in Mr. Sloman's very first records request on September 18 of 2020. And we can discuss that request and what transpired thereafter when you're ready this morning. But let me conclude by saying in my remarks here that we ask the committee to recognize that on reviewing the record, first, there is no plausible reason why the university needed 4 months, 13 days, and an appeal to the university's chief administrative officer to complete the records request 2574, which produced 243 pages of insignificantly redacted email. Second, there's even less credible reason why the university needs an estimated 13 months, 15 days to complete request 2575, which is identical in all respects to the now completed 2574 request, except for the capture window. And this is baffling, particularly when the university admits that it has had the records in its possession since November of 2020. The third item regarding fees, there was a $1,600 and change fee for request 2574 that in all materials presented is unsubstantiated in its need for what was produced ultimately. And we're not necessarily interested in paying for the university's mistakes or bumblings in its ability to provide materials. Then we have the $2,900 prepayments twice now for the 2575 that by all appearances seem to be inflated in view of what the 2574, the identical 2574 request has already produced. So what we ask of the committee is to simply help us get our records. We want to compel, and we ask the committee to compel and oversee the immediate processing and delivery of the public records request 2575 that was filed on October 16, 2020, at some date well in advance of the estimated December 1st, 2021 date. There's no evidence at all to suggest that completing the 2575 request could not happen, perhaps, by the end of June 2021. And instead, the university's continuing solution to the entire problem is for Mr. Sloman to simply withdraw all requests and go away. And that's not what the legislative intent of a public records request statement legislation is intended to support. With that, I'll conclude opening remarks. We can get into the specifics and the details as is needed, but I will pause at this point and reserve the rest of my time for as needed during the rest of the proceeding here today. Thank you.
Thank you. Are there any questions from the committee? So I just have one question on the fees. Have some of the fees been paid, the prepayment?
All fees have been paid, yes,
Okay,
with immediacy.
thank you. So any other comments?
Well, I read through this material a couple of times and I'm confused as to, so you made the request, it was denied, and then Greg Thompson got involved and he said, no, they should get it. But then, and then the university comes back and says, we don't have time to do all of this. Is that correct?
You're addressing me?
Yes,
Mayor?
I am.
Yes.
I'm sorry.
Yeah, well, as I state in the materials that were presented on behalf of Mr. Sloman, the initial request was made. There was an immediate response within the 10 days that said, this is producing way too many records. We can't deal with this. Reformulate your request and resubmit. This particular request is considered closed, summarily dismissed. In other words, one strike and you're out. Resubmit with something more clear, no assistance, no comments, no help whatsoever, no discussion whatsoever on what might help clarify. So the requester is left to simply try again, and one strike, you're out. No, still not good enough. Okay, well, let's try again. All submitted in good faith. To the point where it appears that we have carved up the requests in very small capture date chunks, which seem to satisfy the issues that were raised about too many records. At least the university's been silent on that particular point. I hope that's responsive to your question. If not, please let me try again with clarification.
If you'd like, I could also speak to the appeal to Greg Thompson, if that would be helpful.
So
Yes, would you?
Sure. So the appeal to Greg Thompson was made by Mr. Sloman and essentially asserted that the university had not provided a date by which the records would be produced. And Mr. Thompson agreed with that argument and required the university to provide a specific date by which we thought we would be able to respond to the requests, to provide records on a rolling basis, to try and meet the timelines that we set. And to the extent that we could not begin responding to the second request within a month of the appeal date, that we would refund to Mr. Sloman his deposit of $2,900 until we were essentially ready to start gathering and producing those records. So it was about timing and it was about the process for responding. And we've never said that we're not going to respond. It's about the timing and the cost.
Thank you.
Sure.
thank you for the clarification. So we will now go to the governmental entity, the University of Utah, your team. So you have 20 minutes.
Great. Thank you for your time this morning. My name is Robert Payne. I'm Deputy General Counsel for the University of Utah. And I'm joined this morning by Mr. Andrew Wyrick. He's the Vice President for research for the university, and by my colleague, Laura Ann Stetson. And we really appreciate your time this morning and the opportunity to clarify what's going on in this situation. This morning, we're responding to Mr. Sloman's objections concerning both the amount of time it's taking to respond to the requests and for the cost required to respond to those requests. In his request, Mr. Sloman seeks records of the University of Utah's Pivot Center. And in order for you to understand why his requests are so problematic and why it takes the university a significant amount of time to respond, we think it would be helpful for you to understand kind of the nature of that office. And therefore, I've asked Mr. Wyrick to address you this morning and to explain to you the nature of the Pivot Center and what they do and what their records are like. So if you could do that, Andy, that'd be great.
Sure. So, and thanks to all of you for your time and efforts and review of this request. My name is Andy Wyrick.
Can you hold on just 1 second?
Sure.
Is he a witness that needs to be
Yes.
sworn in?
Should be.
Sure, yeah, that'd be great.
Okay, I've got to find the right language. Oh, I have it. Testimony you're about to give.
You swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth,
I do.
under pains and penalty of perjury?
I'm sorry, I couldn't hear that.
Penalty of perjury.
Yeah,
Yes.
Thank you. Okay, please proceed.
thank you. Anyway, so yeah, my name is Andy Wyrick, and I'm actually the Vice President for Research at the University of Utah. And our job as a public institution is actually to make discoveries and bring those in to impact our community, especially the state of Utah and the Intermountain West region. And so one of the major things that we do at the university is research, but it's not just the discovery piece, it's actually this delivery piece that you bring things in sometimes to commercialization, licensing, things like that, that actually get us into the community to actually do good. So as you might know, we've had companies such as Myriad Genetics, which is the first diagnostic test for breast cancer that's come about, and more recently BioFire, which gives rapid technology for diagnosis of multiple diseases, including COVID-19. So, you know, our job is really to do research and then hopefully impact society. We have a unit that specifically does that. That unit does report to me as the Vice President for Research, and that's called the Pivot Center. And that's an acronym for the Partners for Innovation, Ventures, Outreach, and Technology. And this group is really very important because it kind of handles that transition from discovery to an impact that goes into our society. So we manage with that, as you can imagine, a lot of confidential information, which is comes at a central office at the university. It's responsible for bringing innovation to society. That's the Pivot Center. The Pivot Center is very critical for creating new companies in Utah. It's the biggest one, that a single entity in actually the state that does that.
Excuse me, please. What is the relevance of this?
I'm giving you some background as to what the information, what this group does.
I think
We're
we get to
willing-
make our presentation.
We're willing
Sorry.
to stipulate.
Everyone stop. There's no crosstalk. So please proceed with your presentation.
Thank you. The center is really important for economic growth and job creation in the state, and it provides expertise to bring everything from life-saving therapies to new computer technologies, kind of like what I told you about Myriad Genetics and BioFire. I think, what do we actually do? And so this is where I think it comes, and it's very pertinent to the discussion this morning, is that we manage intellectual property. So we found over 1,500 patents, copyrights, trademarks are each comprised of significant confidential information. So that's part of that information. We have disclosures of confidential information related to intellectual property risks that we manage, and the loss of patentability. The loss of patentability could threaten our contractual obligations, notably the federal government. As you may or may not know, the federal government maintains certain legal rights to the intellectual property managed by the university. And that's because when we're awarded a grant, the university is awarded the grant. So we have these responsibilities with the federal government. So public disclosure of intellectual property by the university could lead to forfeiture of federal research funding and therefore impactful discoveries. We manage license to intellectual property. Currently, our Pivot Center has more than 200 active license agreements to the rights to intellectual property. This also continues to maintain obligations under several hundred additional expired license. Each license contains confidential information the university is obligated to maintain. We manage over 1,500 new related agreements containing confidential information annually. These include disclosure agreements, material transfer agreements, and data use agreements. And in total, the Pivot Center manages well in excess of 10,000 active agreements of this nature. We also manage corporate documents and manage agreements related to equity holdings and companies that we spin out at the university. Currently, we have more than 100 active companies that Pivot manages confidentially and equity and corporate documents for. So what the take home here is we have a tremendous amount of confidential information that by law and by what we have to do at the university is make sure that we do all of this, we look at things carefully. And so what I just went, a public record request, it costs time and associated with a careful search and redaction of these records as we try to identify what's responsive. So when we have broad searches, it makes it much more difficult for us to do those in a timely, responsive manner. I will say that we always, I don't think there's a question here about us releasing documents. It's just the time and the cost for us to go through every email on a generic word to go through and redact confidential information that we may need to do just because of the obligations that we're under. And I think Mr. Sloman knows that given his experience in this area. And so that's really what I just wanted to give you guys a little bit of background and context for the type of records that are being requested. So we have to go through every email document, all of those pieces, and to make sure that we are carefully looking at that to make sure that it's we are responding to responsive records in the manner that we are obligated to do so.
Okay, thanks, Andy. So as you can see, the very nature of Pivot's work involves highly sensitive and proprietary information. And contrary to Mr. Sloman's suggestion, the university was not in a position to simply throw search terms into an email system, have that system regurgitate documents, and then turn them over to Mr. Sloman. We were in fact required to conduct a very careful search of the documents to assure that they were responsive to the request and that no sensitive and protected information was received to Mr. Sloman. Although Mr. Sloman seems to claim ignorance as to why this process is so cumbersome, he's actually uniquely situated to understand the issues here. It's my understanding that Mr. Sloman served in a role similar to the director of our current Pivot Center at some point in time in his career. And moreover, his company is actually the company that created the database that Pivot has used for years to manage its documents. So he has a firm understanding of what that database and what it does and how we use it. He also understands why a search containing words like data, analytics, and metrics would likely result in thousands of hits and thousands of pages of potentially responsive documents. It should come as no surprise that the university research enterprise is all about data and metrics and analytics. So Mr. Sloman was uniquely qualified to understand the situation and to craft grammar requests that were narrowly tailored to get to the information he seeks. The fact that he failed to do so is not the university's fault. Instead, he submitted a grammar request with these very broad search terms and is seeking nearly 3 years of information from the Pivot Center. It's important to understand that when Mr. Sloman's request came into the university, we were facing a backlog of 163 grammar requests, and we were unable to begin work immediately on Mr. Sloman's request. We informed him of this fact and gave our best estimate as to the response time. The reality during the past year for the University of Utah is that we have received no less than 31 requests per month. And as in this past year, in 1 month, received 140 grammar requests. We do our best to process those requests in a timely manner, and typically we're able to process about 40 grammar requests per month. But this means that it sometimes there is delay in responding to requests due to the backlog, and grammar recognizes and accommodates for this possibility. It's also important to note that most of the grammar requests that come to the university are from media outlets and are for records that are of public concern. Another large set of records requests that we received are from individuals who are seeking their own records that may be maintained at the university. And grammar was designed to encourage transparency for the conduct of public business. The university is committed to the concept, and as a result, these types of requests are prioritized for the university's response. And we also take care to respond to discrete requests for specifically identified records that can be quickly fulfilled. In this situation, Mr. Sloman is not seeking records for a public purpose and is not seeking his own individual records. Rather, he is using Grama to conduct a fishing expedition into Pivot's records for purposes that are not entirely clear to the university. Regardless, Grama entitles Mr. Sloman to a response of public records, and we're doing our best to comply. When the university first attempted to process Mr. Sloman's request last October with the general search terms, the electronic search of the Pivot employees' mailboxes identified so many records that it actually crashed the search engine. And this was clearly an indication that Mr. Sloman's search terms were too broad and non-specific, and therefore we denied the request. Instead of revising his search terms to more narrowly seek the records he was after, Mr. Sloman simply divided his 3-year time period into 21 different requests with shorter time periods. But each of those requests contained the same broad search terms. His response created no less work for the university, but did allow for the electronic searches that did not crash our search engine. So we began the process of responding to the requests. His first request of the 20 requests covered a period of only 2.5 months. When the university searched the email boxes of the Pivot employees identified, it pulled back results of over 17,000 pages of emails and attachments. So his search terms appeared in 17,000 pages of documents. And each of those emails and attachments then needed to be manually searched to assure that the university was producing responsive records, but not producing records that contained the protected and confidential information of the university or its licensees. To minimize the cost to Mr. Sloman, the first pass through these records was conducted by an hourly front office employee with the skills to pull out non-responsive records, such as junk email, listserv postings, and draft documents, and documents containing potentially attorney-client privileged communications. The documents were then reviewed by an employee within the Pivot Center who could identify those records containing protected and confidential information. And an attorney in our office reviewed the records that were pulled out with potential attorney-client privileged communications to make sure that those were excluded from the release as well. If that had not happened, if that employee, the hourly employee, had not done that search, then, it would then have gone to the Pivot Center employee to review the 17,000 pages at a much higher rate. So this was what we were required to do, and it's what we did. At the front end of this project, the university gave Mr. Sloman the best estimate of how much time and cost would be incurred to conduct the search and review. Mr. Sloman paid the cost estimate, and in the end, we were short of what it actually took. So we charged him an extra, I think, $400 to complete the first request. There were costs, you should know, that were not charged to Mr. Sloman in the process, even though the work was conducted. So this work I've just described is what was necessary to process Mr. Sloman's first 2.5 month request for information. And now we have 19 more to go. In Mr. Sloman's second request, it covers a 7-month period of time, nearly 3 times the first request. And our search of the database of the emails has produced, in this circumstance, 37,000 pages of potentially responsive information. And based on our experience with the first request, which took 5 months to complete, we estimate that the second request will take at least 9 months to complete, and we've begun the review process. And now, I will tell you that we have, having worked through his first request, we anticipate that we're going to be more efficient in our second one. Our team of reviewers has cut their teeth on the first one. We have a better sense for the documents that are being reviewed. And so, although it's 3 times the number, 2.5 times the number of records, we think that we're going to be able to do it in 9 months rather than 10 or even 15 months. But the reality is that these additional requests are going to take additional time. GRAMA entitles Mr. Sloman to the public records he seeks. However, it does not require the university to incur the cost burden for responding to such requests. Rather, GRAMA specifically entitles the university to cover its reasonable costs for the work. The university has been reasonable in its approach to Mr. Sloman's request, and the university requests this committee to deny Mr. Sloman's appeal. The time and cost incurred to date are the direct result of Mr. Sloman's broad search terms. We believe that Mr. Sloman could, if he desired, craft search terms to more surgically obtain the records he seeks. If he insists upon search terms such as data and metrics and analytics, then he should have to pay for the work of culling through the thousands of pages of Pivot's highly sensitive documents, removing and redacting inappropriate information, and compiling the responsive records. GRAMA permits the university to charge for these costs, and he should pay for them. Thanks.
Thank you. Any questions from the committee? So we're back to the petitioner. You have 5 minutes.
Thank you.
Oh, there you are. Okay, we can hear you.
Okay, good. Many points raised that need to be addressed. The first of which reveals once again that the university has no idea what the actual request is about and completely overlooks that fact, as I mentioned in my opening comments, with regard to the first request. They are not even referring to the first request as actually the first request. I'll get to that. But let me say for a moment here, what generic word data? Please point to the word data that exists in any of these requests that are active, or even the ones that have been dismissed. The word data does not show anywhere in any of these requests. I'll let you do that homework, but I'm happy to read the requests to you if that would be helpful. Regarding the confidential information and the nature of the Pivot organization, awesome organization. I'm well familiar with it, as is Mr. Sloman. But the fact that all of the great work that Pivot is doing has absolutely nothing to do with this request, nothing whatsoever. The content of all the confidential information, all the inventions, all the agreements, all the contracts, all that stuff is fantastic, has nothing to do with this particular issue. What this request is all about, stand back and look at it. It is about the very first request that was made and summarily dismissed. It is about any party, TVC, Pivot, or any other party that is contracted or retained to develop a management information system to support Pivot's operation. We're not interested in the content of that information. All that stuff is irrelevant. All we're interested in are records relating to the replacement of a management information system. That is an extremely narrow topic that is well less than the thousands of documents, potentially relevant documents that are referred to. let me leave it at that for the moment, so that the committee has a chance to ask further questions.
Are there any questions for the requester?
Well, yeah, I have a question. The piece of paper that I'm looking at is Friday, February 19th, 2021. Records of the type identified above, multiple types, authored by any one of the following people. Is that the right one that we're talking about? Because that's not what you read.
The appeal is pointing to two specific record requests, number 2574 and 2575, which are highlighted as being exemplary. What I'm asking the committee to recognize is to stand back and look at the overall situations. These aren't random, isolated requests. It is a requests series that is born of the very first request for information about any party contracted or retained to develop a management information system. That was summarily dismissed because that's too broad and it's creating too many records that need to be reviewed. Please resubmit. We're canceling this request. And the resubmission process, which has led to the document that you just referred to, ma'am, is the attempt, the good faith attempt to try to narrow this down in some way that allows the university to be responsive, which seems like they're asking us to provide the actual queries that will produce the records requested. That's not our job. That's not even what the statute requires. We're only required to characterize what the information is that we are pursuing.
Hey, may I add a comment, please?
I'm willing to
Mr. Sloman?
permit
That's Mr. Sloman. He's the
requester.
Mr. Sloman, who is the requester himself.
Oh,
Just,
so
I
yes,
would like
please,
just
Mr.
to,
Sloman.
if I may clarify, the university focuses and in their statement of facts makes a strong representation of generic terms applied to the search criteria. The word data appears in fact once only in an earlier now completed or dismissed request. And to assist the university in finding this, it's number 2561. The committee should be aware that based on the instruction from Ms. Perkins, paralegal at the university, changes were made to the search criteria. Data appears never thereafter, not once. So the university's reliance on representing to the committee that general terms far too broad for the university to satisfactorily respond to is not accurate. The reasons for that is obviously it serves, well, I'll let the committee conclude on that question. The search criteria, I'm almost finished. The search criteria relevant in front of the committee today from 2574 and 2575 are Intium. I'm sure that Mr. Goodlick will refer to this as well. Intium, infrastructure, Iverson, analytics, metrics, end-to-end, and Minuet. Minuet is the product name, one of the product names of Intium. Intium is our company name and the product name as well. These are very specific, narrowly cast words. We are not looking for documents related, just to reiterate Mr. Goodlick's point. We have no interest in the proprietary information of the university. And finally, these words were guided by communications from a pivot employee.
So just to clarify then, the request is that you want information that has all of those in them. Are there either ors? So you're asking for either or.
That's correct.
Well, analytics and metrics has got to be as frequent as data.
Well, may I respond? What we are looking for are emails written by just 4 individuals. And those individuals, what we discovered in the response to 2574 is that the word data, which was not part of the research criteria, but now is relied upon by the university as being overly broad, appeared 47 times in 243 pages. So that word, in fact, was partly contained in the word database, which is what our system is. So it is not producing tens of thousands of results, the word data. Neither is the word analytics. Neither is the word.
Go ahead.
Sorry. The word data only appears, I think it's 41 times or so in the 2574. So the representation at the university that by searching for the word data, which as we've just discussed, isn't even among the keyword searches, did not in fact produce multiple dozens, hundreds or thousands of responsive records. The people who are authoring these emails do not have occasion to write analytics, metrics, data particularly, and we are not looking for places where those records would appear in any proprietary area that will be redacted in any event.
Any other questions for the requester? So we will move now to the governmental entity. You have 5 minutes to respond and to summarize.
Thank you. I appreciate that. So here's the reality. The reality is that the search terms that were provided to the University of Utah in the 20 smaller requests, which all contain the same search terms, in the first request produced 17,000 pages of responsive records. I understand that Mr. Sloman doesn't understand why that may be the case, but it is the case. So each of those 17,000 pages, each of the documents that the hits for the 17,000 pages of documents contained the search terms that he provided to the university, as is true for the second request, which produced 37,000 pages of documents. And we anticipate for each of the remaining 18 requests will produce a similar number of documents. So we are receptive to the idea of Mr. Sloman revising his request. And honestly, if he took out analytics and metrics, and we're checking this, but we think that data remains in at least one of the remaining requests. If he took out those general terms, it would be a much simpler process for the University of Utah. And so it just is what it is. The facts are what they are. It takes us the time to go through and make sure that we're not producing sensitive and protected information. And Graham entitles us to recover those costs. And if he wants to withdraw his requests and submit more surgical requests, we're absolutely happy to respond to those.
Thank you. Any questions from the committee?
I have a question. So are you searching your whole email database for those terms, or just the 4 or 5 individuals he's speaking about?
Just the employees that he's identified.
Can I ask it? Are the number of pages partly the function that these are emails and lots of chains and duplicates and all of that?
Yes.
Okay. Well,
But nonetheless, we're still, we still have to review them to make sure that that there isn't protected and sensitive and proprietary information. If it exists in one email, it's going to exist in the next. And so somebody still would have to go through that process of deduplicating the records.
So can you give us an estimate of, or maybe if you just removed analytics or metrics, how much would that reduce it?
So I don't know if we've done that search. We haven't, but we could certainly do that. Sitting here today, I expect that it would significantly reduce the number.
Well, then, if you don't know, I mean, how do they know that data, for example, only showed up in 41 in the request that you completed? I can't remember what he said. Didn't he say?
I didn't understand that comment, actually.
Okay,
Would you like me to respond?
yes.
Please.
So the documents supplied to us were in a PDF format. On the keyboard, typing Control F, typing in the letters DATA, gives you a count.
Okay,
It's been part of Adobe for decades.
we
Let
know,
me-
we know about Adobe, thank you.
So
Okay,
just to respond, the records that were ultimately provided for him were obviously a very small subset of the 17,000 pages that contain the original search term. So he may know how many in the, I think 243 documents that he ultimately received contained that search term, but he has no idea of how many documents in the larger set contained that search term.
okay, thank you.
Any other questions, comments? So at this point, it's turned to the committee for deliberation, discussion. Anyone like to start?
Well, I feel like in 2041A double I, how you say that appropriately, it asks for reasonable specificity. And I agree that data analytics and metrics are very broad terms. I understand the argument from Mr. Sloman's team that they apply specifically to this software, but they don't seem reasonably specific to me. I've looked at the code and I feel like fees are allowed for search, retrieval, and other direct costs. And this committee has ruled in the past that redaction is one of those costs. And given the nature of the number of records being hit on just for the people he's asked for, that takes a considerable amount of time to do, having done that myself in my positions. So I can understand that there is a time element concerning here, trying to get the records as quickly as possible, but it takes a lot of time to go through 37,000 pages of records. So, I feel like the university has made a good argument. They're trying to move forward with this as they can. That's just my thoughts. I'm willing to listen to anybody else's argument.
I just wanted to make sure I'm clear. So they've completed one request. They broke it down by time, narrowed it by the span of the dates to the 4 or 5 individuals' email accounts. And that one request returned 17,000, multiple thousands. And that's been narrowed down to 200 and something. So
Yeah, so they took, as I understand it, they took the 17,000 pages in the first request and got it down to the 243. I mean, that's a lot to have to go through
and we have another 20
and
queries to go, right?
yeah.
So if
I
I
don't know how
understand,
you do
my understanding is if what the petitioner is asking for is, why they're concerned about the time it's taking to do this. They were supposed to be done by a certain time, they're not done by a certain time, but the process is ongoing. I don't know that I'd feel comfortable saying you gotta do it faster, because I don't know what's involved in it.
Right.
But if the process has not been stopped, if it's a continuing process, I think they're doing what they can to fulfill their obligation. Maybe I'm simplifying that too much. I don't know.
Well, I think we've also, with other entities, even in a hearing earlier today, we've had them come back and give us updates where they're at so that we're able to continue to monitor that process. I don't know if that's something you want to do here or not, but just, yeah, I don't know.
Well, if I'm thinking about this, what I've heard today correctly, so they're arguing, well, data only showed up, 41 times in our 243 pages. Then clearly data wasn't the thing that was selecting the cases anyway. And I would want to know whether analytics or metrics is just ballooning this whole thing and not really getting them what they want anyway. I mean, it seems like just looking at the what was it, the minuet, or I'm getting these terms
Yeah,
wrong.
Iverson infrastructure.
Yeah, look at those and the emails and the particular people.
Which
would-
speaks to the reasonable specificity of the request.
Right. So what's the code for reasonable specificity?
2041A double I.
Oh, that's the one you
Yeah.
referenced, yeah.
Yeah.
And I would agree that, so is this a denial or?
Well,
This is,
can you clarify, Marie, and I guess Nancy too? So what we're saying, what I'm hearing you say is that when they put the search terms in, it's returning multiple thousands of pages. And the reality is that data appears after all of that work is done to kind of, do the redaction work and the review. We're ending up with 250 pages. And 43 of those have the word data.
Yeah, but we're talking about also 5, 6 different terms, right?
Right.
So that's expanding the number of pages.
yeah,
And yes, while minuet and intium are going to be
They would be very specific.
very specific and less, cumbersome, as you agree, analytics and metrics are pretty generic terms. And I can't speak to how their software works, but ours, we have to do that search 5 times. And then we don't have a great software, I admit it, but, and then we have to get all that put together, and then we have to go through all those pages and look for those 5 terms. That's my experience.
You would do 5
Different
different
searches.
searches and to continue to narrow it down, make it more specific.
Yeah.
But we can't
Right.
speak to how their
Right.
software works.
but I think what we can say is, well, I don't know what we could, I think what we're saying is that we deny the appeal based on the lack of specificity and feeling that the use of metrics and analytics and what we, just those two, data, analytics, and metrics is likely the problem. We don't know.
Please stop saying the word data. That is not part of the request.
I think what's happening with the word data is it's showing up in responses in emails. It
Right,
wasn't
well,
part
and
of the
that one's
request. And
come-
so
they
I don't think
used that the
data is the
first
victim.
time,
I
but
don't think
not
that's
since
the
then.
culprit here. I
Yeah,
think it's. the
I
other-
agree that it's not now,
Yeah.
so
But certainly analytics and metrics might be,
could be, right.
but, there's a difference between saying it's not our job to write their queries and working with someone to say, we tried this effort and it returned 37,000. Do you really want us to look at all of them? Or do you want to give us different choices on your words? So, but I don't want to really deny
Well, deny,
deny is not really the word, right? Because we're not denying the request. They need the data, but they need to work better between the two to figure out what how to get the data they want.
So are you recommending that it be denied, that they advise them to submit another request? Like
Well, no,
revise
we don't need any more requests. I don't
know that I like that as well, just because, I think, I do agree Mr. Sloman has tried to do that already, if I understand the arguments, right? He's tried to narrow it, and this is what they're getting with him trying to narrow it. That's how I understand what we've heard. So what I don't know, I need to understand, Paul, is, because that's why I brought up the continuance scene, and I know how much I feel like if we deny, then the request completely stops. But they should continue to work on this, meaning the University of Utah has an obligation to take what he's given them and do this work.
That's what I was saying. If
So-
we deny, do they submit another request?
So not being a committee member, I'll be careful on this. One thing you could do would be to continue this, because what I'm hearing from the university, that they might be able to narrow the search and do something that's productive between them. Continue it for 30 days and give them the chance to try to work it out. If they can't work it out, they come back and say, we can't work it out, and then you make a decision. Grant the request or deny based on lack of specificity. But I was hearing some things were being said by University Council saying, well, we could do this and do this, and maybe they can have a chance and work it out.
Right.
Well, a continuance would certainly be better than a denial in this case, because you want them to get their data. But there's clearly a problem with the search terms. Somehow, I don't know what it is.
And there was one other thing I heard that I don't know if you want to clarify or just that there's a part of the fee structure that says a governmental entity may not charge a fee for reviewing a record to determine whether it's subject to disclosure, which is under 2035A. So redactions and things like that, they can charge for, but to have an attorney go through and figure out what needs to be redacted, you can't charge for it. Under grandma.
Well, I wouldn't be in favor of a denial, because first of all, it sounds to me like the process is continuing. It's just continuing too slowly from the petitioner's standpoint, but they're not being denied getting the records. It's just taking them a long time to get them. So I'm not even.
I know that,
Other
where
than
do you go?
other than the continuance or us doing something which I don't think we're authorized to do, which is say, reappeal it, take out a couple of these words that are causing the roadblock. I don't think we should do that.
No.
I don't feel good about denial, because I think the process is going. It's just going slower than maybe all of them would like it to go.
Well, and the third one option is to say to the University of Utah, stop the delay and do it now, and that doesn't seem possible. Yeah, so,
Was that motion from Tom? Is that what I heard?
Well, I'm not sure what the motion would be, because it's like that, granted in part, denied in part. No, we're not even there, because I don't think there's a denial involved here. I'm not really sure the appeal is speed them up. I don't know how we could order them to do that.
right, and that's, I think that's what the feel is we want it now, but.
Yeah. Can't really order them to speed it up with a continuance, obviously. You can encourage them to speed it up and come back before us in 30 days. That's up to you.
That's probably our best option at this point, which I do not feel like that's not. All right, I'll try it.
Okay.
Say, go ahead.
Oh,
No,
gotcha.
go ahead.
Can I ask the University of Utah a question? Just, would that be okay? Mr. Payne, are you willing to do certain, as you get send some over, are you waiting until you have it all in responsive to that request and then sending it all at once? Does that make sense?
Yeah, I understand your question. Let me respond to your question, and if I haven't answered it, let me know. But actually, part of the requirement from our chief records officer in the appeal that was made to him was that records should be provided on a rolling basis. So that's what we're doing.
Okay, thank you.
And just to clarify, we're not asking you to tell us We're not asking for you to say we don't have to respond to his requests. We understand we have to respond to his requests. It's just taking time and it costs money.
Well, and
And he can obviously, if he wants to revise his requests, we'll certainly consider that as well.
in your fees, are you calculating the time for someone to review those records? Because according to Grandma, you can't calculate that in the fee.
We are charging costs to determine whether or not the documents contain proprietary and confidential information and to redact that information, which we believe Grandma absolutely entitles us to charge.
Not through an attorney. Isn't that what?
No, just the gathering,
The
the
gathering
searching,
part and the
getting the
searching.
records together cannot be charged.
Right.
We have to, when we produce a redacted document, we're producing it in a form that it was not created in originally, right? I mean, we have to remove information to provide it in a different form that it was in the first place. So we think that Grandma entitles us to charge for compiling information into a different format.
So staff time, search, retrieval, and other direct administrative costs for complying with the request, you can charge for. The
Okay,
costs
thank you.
that review the record to determine whether it's subject to disclosure, you cannot charge for.
Okay, thank you. Thank you.
No, you go ahead. I insist.
No, nothing. I remember I made the last
Oh,
three
yeah, that's-
motions.
Well, I don't know, I guess I would make a motion that this be continued to give the parties a chance to continue this process of producing records, getting into the petitioner, because it sounds like that process is ongoing. And that we are continues and have them come back and to report to the committee at a different time, if it's next month, if we want to give them. It's probably not gonna happen in 30 days.
Rebecca loves next month.
Okay, well, we'll start with next month and you can change that.
Okay.
So that we can review and see where this process is at.
Or we just have to say, next available hearing.
Okay,
Yeah,
next available hearing.
yeah, let's do that.
And if a friendly amendment, that we would encourage the parties to negotiate a little bit to allow the University of Utah to explore different searches,
And maybe work with the ombudsman.
or maybe different search parameters is what I want to say.
And maybe mediate through the state records ombudsman.
Yeah,
Or work with petitioner to clarify the request.
To work
Throw that in
with the
there, too.
commissioner to clarify the request.
Yeah, so that, but
All those friendly
anyway,
amendments.
yeah. friendly
although
amendments.
I would prefer that we actually use the term research parameters. Because seems to be the problem.
I'm okay with that. So that's my motion amendment.
Okay.
So Rebecca, do you have that motion?
Second. So the motion is to continue to the next available hearing to provide more time for the parties to explore different search terms and work with the ombudsman.
What was the?
Search
Research.
parameters.
Search parameters. So is it to clarify the request or to clarify the search parameters?
Yeah,
Put them both in.
Okay.
yeah.
For clarification and for search parameters. Clarification and search parameters, how's that?
And is working with the ombudsman part of the motion?
And we encourage. the
Or
parties to work with
encourage it.
Can't order them to, but
Now, Rebecca, that being said, as part of that motion, I don't want to be, I want to make sure it's clarified. I'm not asking that the petitioners change the information they're looking for. I don't want to say we have to change the wording. We may not get everything we want.
Right, it
just need to
says
be able to
to
work-
clarify the request
Yeah,
and search
Work with
parameters.
respondents so they can get this expedited.
Okay.
Oh, and I'll second that.
Okay, we have a rather interesting motion from Tom
Yeah.
and a second
Tom doesn't
from
make
It was
them.
beautiful. I
I
loved
thought
it.
from Marie.
Brilliant.
No, I thought it was well done.
I'm a writer for this. Again, just for discussion to that, again, I think we're in an interesting situation here because it doesn't sound like anybody's trying to stop the other person from fulfilling the order. It's just taking too long.
Yeah,
It's very strange. It's not, there's none of,
Another denial.
Right.
denial.
Right.
but we got where we wanted
Well,
to
it's-
be by starting with denial.
Yeah.
No denial. I think you started that.
Yeah, I know. I just want to point that out. I started it, but we got to a good place.
So any further discussion to the motion? Hearing none, we will take a roll call vote. So starting with Tom,
I'll vote aye.
Marie,
I,
Nancy,
I,
Mark. Aye. And I vote aye. So Madam Secretary, the voting is unanimous. The motion carries. We'd like to thank the parties for being here today. Thank you for your time.
Thank you for your time. We really appreciate it.
Thank you.
We appreciate it. Will we receive a record of this recording and the official motion that was just passed?
It'll be made available to you within seven business days.
Yeah, there will actually be an order from the committee that states what was in the motion, continuing it to the purpose for the continuance.
The recording will be on the public notice website tomorrow.
And the recording's on the public website tomorrow.
does he know about it? Is he from Utah? I don't know that he's from Utah. The Utah Public Notice website.
Yeah.
So are you familiar with the public notice website?
Not directly, but I'm about to learn.
We'll have the secretary send you links to the website. That's where the recording and all of the information for this hearing will be.
Very good. Thank you.
If you have any other questions, feel free to reach out to the secretary.
We look forward to the opportunity to work with the university to get through this.
Thank you.
Thank you.
Thank you very much.
Signing off.
So we have 15 minutes before lunch. Paul, did you want to give your report now, or do we want to break for lunch?
Yeah,
The next hearing is at 12:30. We could have moved it up.
Okay. That's fine.
So the parties aren't here.
No.
Okay.
Interested people.
Yeah, I can absolutely give my report at this point.
Okay.
I have emailed it to Rebecca. She can put it up on the screen. And we can go from that. What was funny was even after I sent the report, I had new information come in. So this will be kind of fun. So new live update.
You have like an
And-
audience, you have a live audience now rather than just,
What's that?
you have a live audience now. Every meeting.
I know.
You two are always together. We're all different and it's like real people talking to walls.
There you go. All right. Can you see that there? And I mean, Rebecca said, for example, that we've got a few more appeals coming through Stecklow. Without that, all the cases we had there at the end of May. No, end of April. Oh my goodness, I did not do a spell check. Can you remove one of those R's there? Yeah, thanks. Oh, do not judge me based upon a quick doing. At this point, we have only received a summons from one of the cases, and that's Washington County versus Stecklow. Actually, kind of interesting. It's in 5th Judicial District, which is a little bit different, but we were just served yesterday. So I'll be filing an answer on behalf of the committee. I have no idea how Mr. Stecklow, if he has like 4 appeals, does he have an attorney? He's going to take them. He's going to try to come out. I don't know. In any case, I'll just make sure that we have an answer filed on behalf of the committee, and we'll be pretty much third party on that. Cantwell versus University of Utah. Complaint was filed. We just filed the answer 2 days ago. University of Utah, they asked for an extension, so they're going to file their answer pretty soon. Going through the ones that don't have asterisks at the end. Again, if it has the asterisk, is something that's nothing has happened since last time. So we'll drop down to Blake Johnson versus Judicial Conduct Commission. The final order judgment was entered May 10th. You have 30 days to file an appeal. Today's June 10th, so I almost took it off, but maybe if they're going to file an appeal, they'd have to file an appeal today for Court of Appeals. If no appeal is filed, that case is completely done. So we'll just wait to see. I thought when they asked for the audio recording, they might be filing an appeal, but nothing's happened on that. Patrick Sullivan, about the only thing that's happened recently is that there was a request for discovery filed on June 2nd. So they may be going forward more on that case. Dropping down to Big Game Forever. We have the summary judgment hearing is set for August 11th. Should we probably check to see if we're going to be meeting for state records at the same time? I hope not. But you've got competing motions for summary judgment going on that case. We'll see what happens on it. Okay, drop into the next page. Beaver County. Oh, I got to ask this. That should be dismissed by this point. They settled everything out February 1st, but they just haven't filed a notice of dismissal with the court yet. Gallagher versus Morgan County had a hearing on that May 18th. Arguments made by Morgan County why summary judgment should be granted. Mr. Gallagher was able to argue against it, and the court ruled from the bench summary judgment granted in favor of Morgan County, upholding the decision of the State Records Committee. There's a proposed order that's been drafted that's being circulated among the parties. And once that has been circulated, it'll be given to the court to sign off on that or make any changes as needed. But that case is done, at least as far as the district court level. Platt versus the Utah Attorney General's office. We have a 3-day trial scheduled for that, July 26th to the 28th. We just had a request to set aside an order filed by Mr. Platt's attorney, Paul Heyman, on May 31st, 2021. We have a lot of different kind of motions still going around, but hopefully they'll all be clarified before the trial. But if it's a 3-day trial, that'll be the longest trial we've ever had on a grammar case. So should be fascinating. ACL versus Davis County. Most of the issues have been settled with that because they did have a trial on it. So the court is pretty much having a scheduling hearing on June 28th to really see what issues are still out there and to see if we're going to go forward on anything else, or if the case is done, then we'll have a final order of judgment. Paul Heyman versus Utah Attorney General's office. We have a motion hearing July 7th. The goal again for that one is to get to a trial date. Mr. Heyman wants to have it in person. We are getting closer. Talked to Judge Skanke just off the side of one of the hearings recently. He said apparently the courts they're looking at August 1st is kind of the day when they're going to start doing things more in person. I am curious to see how COVID has affected things. That for a lot of these things you can probably just do by video. We might have more video court hearings, and some things are trial being done in person. But because the courts have been set up with the ability to do these things by video, we may have moved into the 21st century in the court system and have more video hearings. So that's kind of nice. The other two, nothing happening in that. We'll get down to Anisco. So the first one up there, there is a hearing scheduled on Monday. It's on the committee's motion to dismiss. Remember, this is the case that was filed by Mr. Anisco. It was filed only against the State Records Committee. It was not filed against the AG's office, whose records he had requested. The complaint was based upon the committee's refusal to allow him 2 separate hearings on the same issue with the same governmental entity, but there were different records requests. So we had combined them together because we're busy, and he objected to that. That is the issue he has on the appeal. The argument made in the hearing for the motion to dismiss is that it's not an appealable issue. He can't get relief from the court for what he's asking for. We've already have a notice of compliance that's been filed by the AG's office. He didn't name the AG's office as a party. We're basically there because he wants to have the court say State Records Committee is wrong for the way the order was written, for not allowing him to have 2 separate hearings, internal things. And the interesting thing about this is that I filed my motion to dismiss before I even had the opportunity to request to submit for decision. The court scheduled it for a hearing. From my experience, that's usually a good sign that the court wants to get to the issue quickly. So we are going to be, I'll be arguing that on June 14th by WebEx if you want to join in. It'll be lots of fun, I'm sure. There's a good chance that the case might be dismissed at that time, at that hearing. There is a motion for summary judgment from Mr. Nisco. As soon as the court scheduled the hearing, he waived his right to reply memorandum for summary judgment and then asked the court to consider his motion for summary judgment at the same time. Don't know if the court's going to do that or not. The next one, the DEQ, we had a hearing on May 11th, and court heard the arguments for everyone, and the court granted summary judgment, partial summary judgment in favor of DEQ, and also granted the motion to dismiss of the DEQ employees that were included. There are a few kind of small other issues because the law itself has been established in the case by the motion for summary judgment. So DEQ is still going to file a motion for summary judgment to take care of all the other issues in the case. I'm going to file a motion to dismiss Ms. Mansfield because based upon the DEQ employees being dismissed because they're improper parties, it's pretty easy to say, if they're improper parties, so is Ms. Mansfield. So she'll get dismissed out pretty soon. The hope was that the whole case would have been disposed of with the motion for summary judgment. That did not happen, so that's why I'm going to file that motion. In the next case here, I'm going to talk about that case and another case as well. If you remember Mark Tracy, Immigration Improvement District, the Homeowners Association, he had been found to be a vexatious litigant by district court. He filed a motion to join as a third party both the DEQ case and the Immigration Improvement District case. We are actually scheduled for a hearing to hear his motion to join as a third party on June 22nd. His reasoning was that he made the same grammar requests that Mr. Nisco had made in both cases. And even though he did not file an appeal of the denial of those requests, whether from the State Records Committee or from Chief Administrative Officer, I can't remember if it's both or one, he still wanted to join in the case because he has an interest in those. You can't do that. You can't revive your appeal because someone else asked for the same records that you asked for. That was going to be the argument that was going to be made by Immigration Improvement District. Well, they made in their memorandum contra. DEQ is going to make the same argument. Today at 10 o'clock, 3rd District Court issued an order basically saying, no, you don't have to do any of these. He is a vexatious litigant. He's supposed to ask for leave from the court to file anything in court. He has not asked for leave, therefore, no need to do anything with it. So he's done for that issue unless he asks for leave for the court, which probably is not going to be granted in these cases. So that's how vexatious litigant orders work. The court did that sua sponte. I mean, it was going to be part of the arguments for the other ones that he's a vexatious litigant. He can't file stuff, but the court just kicked him out. 10 o'clock today, so that was interesting. And the last one is nothing has happened, but just keeping updated. It's in the Court of Appeals now. Mr. Nisco filed his appellate brief. He didn't argue the merits of his case. He argued technicalities. The big one is that there's a motion to dismiss and there's a memorandum supporting the motion to dismiss, and he put, so we had in the motion to dismiss dismissal based on 12B1. Clerical mistake, it should have been 12B6. So the whole memorandum argues 12B6 all the way through. And he's claiming he should get a reversal because it says 12B1 instead of 12B6, but then stays away from the merits of like, these are issues that shouldn't be for the district court. I imagine now the arguments will be made by the AG's office. Civil Appeals Division is taking care of it. I'll probably be getting with them to help out. Their one comment was, oh my goodness, I can't believe how many things got filed in this case. I said, yep, I lived through it. It was wonderful. Good luck, Godspeed. But we'll see how that case goes. Again, the motion to dismiss was granted by the district court. That is what's being reviewed by the Court of Appeals. A lot of things may be finalized in Mr. Nisco's case that's coming up pretty soon, actually. So that's it. Any questions?
Oh, how do you get qualified as a vexatious litigant?
You have to work really hard. Really hard.
The judge does it, right? That's
Yeah,
what we did
the
with
court does it. There is in in the rules of civil procedure, it actually outlines what are the different qualifications in order for a fine to be vexatious. As you may remember, Mr. Roger Briner was found to be a vexatious litigant because of the things he filed against the state records committee. And a good way to kind of describe it is if you are filing things that I would say superfluous or just to harass, that don't have any legal merit, basically wasting people's time, wasting the court's time, the court on its own will step in and say, no, you can't do this. Even if you have a vexatious litigant finding by the court, what it means is that you're not precluded from filing things in court. What it means is that if you do file something, you have to have an attorney sign off on it as well. So for example, me as an attorney, I can't file anything that's, the words I'm looking for, I want to say, it's not superfluous, it doesn't say superfluous. Things that have no merit, I can't do that. If I do that enough times, I'll probably get something from the state bar saying, you as an attorney, you're an officer of the court, you're supposed to do this and this, and you're not doing it right. We may have sanctions against you. A pro se litigant doesn't have a state bar that oversees them like with attorneys. And so the vexatious judicial rule is basically the ability for the courts to oversee pro se litigants to make sure that they are following court rules. And that's the sanction. And if you don't follow the court rules, the only way you can file things is with an attorney who has to sign off, who then has a responsibility at the state bar. So you abuse the system, eventually you lose the right to file in the system.
Oh, so they're still able to, but they have to work with an attorney.
Yep. And so if the attorney files something on their behalf and does it in such a way that there's no merit to what they're filing, the attorney will get the sanctions. And oftentimes with vexatious litigants, they usually never file anything because they can't get an attorney to file things they want to. For example, if they file just motion after motion after motion on things that just have no merit, that will get the court not happy and get you a vexatious finding.
So hypothetically, you could have a petitioner that really only files one appeal, but ends up being vexatious. So they're not filling the court with appeals. It could be just emotions.
Yeah, just for fun, since we still have a little bit of time, let me pull up the rule really quick and I'll go through, let's see, rules, civil procedure. The rule itself, and I think there were only, I remember the court telling me there may be 8 or 9 people total in the whole state of Utah. So Mark Tracy is 1, Roger Reiner's 2, maybe like 7 others. In any action, the person 3 or more times does any one or any combination of the following. 1, files unmeritorious pleadings or other papers. 2, files pleadings or other papers that contain redundant, immaterial, impertinent, or scandalous matter. 3, conducts unnecessary discovery or discovery that is not proportional to what is at stake in litigation. Or 4, engages in tactics that are frivolous or solely for the purpose of harassment or delay. You do any of those 3 or more times, you might be a vexatious litigant. And the court makes that finding. And they hold a hearing and say, okay, here's the charges against you. We feel like you have done CI, C3, C4. Present why you think that what you filed was meritorious, or why you don't think this was frivolous. In Roger Briner's case, he said, I lost on every single one of these, but these were meritorious because of this. And the judge just kind of listened and offered me an opportunity to say anything. I said, nope, I'm good. City Clearfields, they maybe said pretty much they're good. And the court just made a finding and said, based upon the evidence in front of me, I find you a vexatious litigant. And once the order goes in, it's Utah-wide for all state courts.
Did we file that complaint or something?
No.
Who filed the complaint?
The judge.
The
The
judge?
judge.
Oh,
sua
isn't that
sponte.
interesting?
And for those of us that were back in the Briner cases, he was just filing stuff that had nothing to it, and the judge, and then he was, well, calling the judge names. That's never a good idea
I think
either.
that's when it went, when he started calling the judge name.
Yeah, he's like, Judge, you're not following the civil rules. You don't know what you're doing. Well, again, if the person is making a decision on your behalf, don't call them names. You're not going to engender, oh, you're right. Oh my goodness, I am not following the civil rules. Here you go. It just kind of went downhill from there. Well, in Roger Breyer's case, I mean, he had asked for the judge to be removed. He filed stuff above him, and it was a lot of things that, even with the parties involved, with the court itself, there was harassment, delay, and the court finally just sua sponte said, we're having a vexatious litigant hearing. Here are the charges against you. Answer them. Otherwise, we're going to enter an order of vexatious litigant. And Mark Tracy, looks like, I mean, that happened not in our case, but it was another case, but it's now applied to our cases. When he tried to come into third party, it is not something you want to have. And the court is very deliberative when they do those things. Roger Briner actually appealed that all the way up to the Supreme Court, and it got affirmed all the way up. Any other questions? You have an interesting job. I do have an interesting job, so
You
it's
have
fun.
interesting clients too.
I have many interesting clients, and you're just one of them. And-
Thank goodness. Just one.
But you might be the most fun. Yeah, definitely. So,
Wow, how sad is that if we're the most fun?
Yeah.
well, purchasing and fleet have made it fun recently, so just saying. I'm getting DTS soon, so they're going to be fun as well.
All right, well, is lunch served?
Lunch is in the, what's the room called?
It's in
Skull
Skull
Valley.
Valley.
Let's go. Most of it's still
Might be a
out.
little
Utah
worried.
Spark guys do that, but it's very
And the
rural.
lunches aren't labeled with your names, they're checked with what you ordered, and they're very specific, so don't take what you didn't order.
So take whatever you want. then.
Just take what you did order.
That's what I heard.
What they call it, Skull Valley.
Yeah. Great. Could be idiot Skull Valley. So- Oh dear.
Let's go eat lunch.
All
Okay,
right, so
we're gonna
we're
break for lunch. We'll
Is
be
it-
back
is,
at what
well-
time, Rebecca?
The next hearing starts at 12:30. They might be here a little early. I don't know.
Okay. Should we come back at 12:15?
Sure.
And if the parties are ready to go, we can start.
One of these from my office. I'm gonna check the price out on these.
Four, three Dodgers. Top of the six.
Top of the six.
Top of the six. Yeah, ESPN is awful. It's on YouTube, free game of the day.
Jazz game tonight,
Is that?
right? Jazz on the playoff. Tom.
Kidding.
Yeah.
I didn't watch the last game because they were behind. So I just watched it.
Oh, my team is going to get to the semifinals or something.
Oh, yeah, I like it. Yeah,
Oh.
I like big basketball.
Are we ready?
We're waiting.
Oh.
What's that? I won that jazz halftime show. What?
What'd you do?
Whatever time it's anyway.
Musical chairs.
You won a musical chair.
Got to go to LA with the team.
Oh, that's incredible.
I'll have to show you a picture sometime. I was much younger.
Wait. Oh, so it wasn't just this last time, there was some.
No. Years ago. They played the Lakers. Yeah. One of the last games of the forum.
Oh, wow. Do you have it on Facebook?
Oh, no.
Oh, no. Yeah, that'd be fun to see. Absolutely.
All right, I think everyone's back. Recording's going. Yeah, okay. Ready. Thanks for sticking with us, and I think you've watched the last couple of hearings, so you know how it works. But we will start with presentations from both of you, 20 minutes, and then we allow 5 minutes for closing statements. So I do need to read a statement. The Utah Mediation Act, communications are so from the Utah Mediation Act, communications or mediation with the government record ombudsman cannot be used in this appeal hearing. I just need both parties to acknowledge that.
Yes.
Yes, I understand. Thank you. So we start with the petitioner. You have 20 minutes.
Thank you. Thank you for your service, for shining sunshine in places where sometimes it's obscured by unethical actors. I'll start by saying I guess 5 years ago, I was here in front of the state records hearing, and ironically, Commissioner Lee at that time proffered the dissenting opinion, which led to upholding my appeal. I feel for those who are obligated to be here and try and represent the dark side. But thank you for being here, Adam.
Hey, no problem.
Ironically, it was your pushback that outlines the flaws presently in our state of Utah. And this is something, Kenneth, I think that needs to be taken up with the state auditor because it's pervasive in Utah. We are behind the times technologically. When Adam and his team had to go to the Utah County Commissioner and say, show us your information, that's flaw number one. You shouldn't have to do that. There should be a database, there should be access by the county recorder to all germane records. Are we contesting that a text message is a record or potentially a record? That's a question that I would ask the body here, and one that I'd like Adam to respond to. I've got case law in front of me. Cincinnati, Ohio versus Sinclair Media. Private text messages that have been commingled with government records carried in the pocket of elected officials. That's our number one liability, I think, in the state of Utah. Intellectual property that is garnered or produced by an elected official during the course of their tenure is state property or county property, or should be. Presently, we let our elected officials walk around with IP in their pocket that has not been categorized by the records officer, and oftentimes is kept from the public. You have in your Google Drive several exhibits, one of which is the most damning of which is Commissioner Lee talking to a constituent via text message, which your team has not been able to produce.
They said, we don't have it. That's issue one. Issue number two is what do we have to do process-wise to get adherence and compliance? Best practices suggest, and in talking with elected officials in high places that are ethical, they said, Mark, your request is grammar 101. The problem is the commingling of information. So these elected officials carry two devices. One has pictures of their babies and grandkids and kids jumping in the pool, the other is just for government use. So at the end of the day, I think that's where we need to land, so that records are not commingled. Elected officials can't say, trust me, I don't have anything. I have given Utah County the opportunity to become the epicenter of ethics with my repeated grammar requests. Every time I've hit a roadblock and I've turned over rocks, I've either found obstruction of justice or somebody that's covering their CYA. That's the problem. County Attorney Levitt should not have to deploy staff time for this. We should instead turn it 180 degrees and say, what do we need to do to become the most transparent institutions in the nation? This request is really similar to the Hillary situations back in Washington, D.C. And I appreciate that Adam has tried to narrow this down to one email or text sent to Richard Losey or his architect, but it's not. That's not the request. The request is that has not been fulfilled is please provide responsive records of all cell text to or from 801-722-4646, Commissioner Lee's phone, and to or from Mr. Richard Losey, and to or from Mr. Curtis Minor. Redactions are fine. But item 3, element 3, please provide all copies of all incoming and outgoing text messages related to Bridal Falls and public comments from November 1st to December 14th, 2020. Please provide all responsive records to or from Brian Volks for the same 3 requests above. Please provide all emails from Ezra, that's Tanner Range's assistant, regarding Bridal Falls, meetings to discuss Bridal Falls. Please do a server-based research. So that's really what I'm asking here. I'm trying to get context around Bridal Falls. The YouTube commission hearing indicated by Commissioner Ainge that he had received more than 770 inbound emails and communications. So I'm seeking those from Commissioner Lee. What did you get? Either to your email address or your cell phone. So when county attorney approached Commissioner Lee's office and said, do you have any cell records, text messages? I don't know if the request was so narrowed down to just to that of Richard Losey, but I'm asking for context. I'm asking for everything from the public, trying to create a record. We know the past, we can figure out the present, then we can determine what the future will be. But this request really hits every legislator, every senator, every mayor, every elected official that's using their personal device to communicate. That's what this is really the heart of the issue. Are we going to allow processes to stay in the dark ages? Are we going to require full transparency with checks and balances? Checks and balances don't include just saying, hey, do you have anything? They say no. It's requisite upon being able to have server-based queries, being able to have regular routines for procurement of those records, or a records officer to classify those records if they're protected, classified, or the public. In Commissioner Lee's dissenting opinion back in 2016 regarding Utah's GRAMA statute, the legislature's intent is to favor public access when the application of this act countervailing interests are of equal weight. Except where disclosure is forbidden by law, my vote is always for more openness and transparency. Well, I'm playing ping pong with Billy now, because he doesn't want to be open and transparent regarding Bridal Falls. 63G 2801 of the Government Records Access and Management Act, Part 3C. A public employee who intentionally refuses to release a record, the disclosure of which the employee knows is required by a final unappealed order from a government entity, the State Records Committee or a court is guilty of a Class B misdemeanor. You've got an exhibit in front of you that demonstrates that Commissioner Lee's withheld at least one record. I would ask David Levitt and Kenneth William, the governor's appointee, to dig into that. This needs an audit. And I'm not singling out Bill Lee. I like Bill. He's withheld information. He's denied grams before with help that had exculpatory evidence. He's obstructed justice. I won't go into that. But that's what's at stake here. We're either going to set Utah back a decade, or we're going to say, you know what, Mr. Allen, you're right. We don't have any process in place. We let all of Tanner Ainge's text messages that were germane, and Larry Ellison's, and Doug Whitney's, and Gary Anderson's go by the wayside. Not only that, but we let them leave office with all the county IP in their pocket. That's pretty scary. We've seen cyber attacks recently, right? You don't need to do a cyber attack. All you need to do is hijack one of the legislators' phones. It's worth millions of dollars. God forbid anybody do that. We need cell phones turned in on a regular basis. We need records procured. We need databases. I'm up for retaliation here. Commissioner Bill Lee and our Bridal Falls thing with friends like Mark Allen, who needs enemies. Do I sleep all at night? No. Should something happen to me, turn over the rocks. State Records Committee upheld my grammar request back in 2016, and ironically, Phil's dissenting opinion Item 6, after hearing the arguments of the parties, reviewing the written arguments and applicable statutes, the committee finds respondents' arguments unpersuasive. I had 2 county commissioners who were trying to say their email addresses, their government email addresses were off limits. Continuing, the committee finds the respondents' arguments unpersuasive. The evidence presented instead shows that respondents' actual practices to allow email addresses of Utah County employees to be used publicly. For example, board member William C. Lee noted in his dissent that business cards for Utah County employees contain their email addresses, work phone numbers, and in some cases, their personal cell phone numbers. In efforts to defeat Prop 9 down in Utah County, Bill Lee suggested to the public on Facebook, hey, here's my cell phone, contact me. I'm all about openness and transparency. Well, if that's the case, my next gram is to Prop 9. Show me all the inbound emails and cell phone messages on Prop 9. A month ago, Commissioner Bill Lee and his partner, Tom Sakovich, decided they were going to take over the $500 million county budget. And with the 50% voting power, they did per day. So the governor and the lieutenant governor said, knock it off. You guys have gotten too big for your britches. Come on. That's what's at stake here. And it's not just did Bill Lee communicate with his text phone and a developer. It's how many messages has he commingled that are rightfully in the public's interest to know. They're public records that have not been classified. He may be walking around with it in his pocket IP from the Silicon Salt Company. Would they be aggrieved if that were lost or hijacked? Could there be damage done? Absolutely. So this is about locking things down and making things tighter so that the public can trust our elected officials. And Bill Lee ought to thank a guy like me that's willing to take my energy and time to say, I'm just trying to give you an opportunity month by month to demonstrate to your constituents that you're transparent and honest. And it's not just Bill Lee. It's David Levitt, it's Governor Cox, those that I've spoken with over the last couple months, they've simply done a best practice, which is here's my government issued phone. I know it can be audited at any time by any recorder. I know that it's used for official communications. I have no problem with it. I can delve into specifics, Michigan Supreme Court rulings, Ohio Supreme Court rulings, text messages of public records. Bottom line is we don't have best management practices in Utah County. A handshake and a wink, and yeah, trust me, that's last decade. We need better. I'm here asking that you create a process for auditing, a process for best practices. It doesn't take one very long. You look up any news, anything that's in the news lately, chances are 98% that's text messages have been a part of whatever's going on, right or wrong. It's a new method of communication and we're behind the times. So please keep a broad scope on this. Don't be fooled by having the argument narrowed. And I appreciate the awkward position it must be for, I know it was for Paul Jones when he tried to defend the prior two commissioners, saying, you know, email addresses are private. I feel the same for you, Adam. This is monumental. This is history being made in the process right here. And we don't have to look very far to realize the importance of such. Our nation's founding principles are at risk every day because we have elected officials that obscure or they provide shards of truth. They cherry pick. When I do a grammar request, commissioners should never know, but Mark Allen's doing a grammar request. There should not be opportunity for retaliation, but I'm wide open. My underbelly, they know my home address. I don't sleep well at night, but I won't shrink from what needs to be said. We can do better. We must do better. You have the capacity to order such, and I request such. Thank you.
Thank you, Mr. Allen. Any questions for the requester? Hearing none, we'll go to the respondent.
Thank you very much. And thank you very much for having us today and for hearing this. My name is Adam Beck. I'm with the Utah County Attorney's Office. And this is Laura Mendoza. She's a paralegal that works over Grandma County. The question before us today is not whether a document is private, protected, controlled, or public. And the question is not, there are these text messages, are they subject to grant law? We're not there yet. The question is whether there is a record that is responsive to Mr. Allen's request. Now, I'll just go through kind of the timeline from our perspective, what it looks like. We received Mr. Allen's request back in December. He sent us multiple emails, and each email was multiple grandma requests under each of them. So it ended up totaling up to be about 21 different requests. And so we claimed extraordinary circumstances and said we were going to respond to them subsequently. We'll just take them, we'll just go down the list and we'll respond to them. Now, we got to the one that's at issue today, the one that he's appealed to our commission and is before you today. How it looks from our perspective, we got the request and we looked through our records that we have in our database, in our servers. Utah County does not prepare, own, receive, or retain records from county employees' private devices. That's something we don't have. And so per his request, he's not asking for a record. He's not asking for a record under section 63 G2 103 22A. Now, but we understand that even though it's not within our database, we know that there could be records available that we don't maintain. So we reached out to those people individually in our county who could potentially have records that would be responsive to Mr. Allen's request. So we turned to the Board of Utah County Commissioners, Bill Lee being a member of that commission. And yeah, we sent the request over there, said, this is the request. Will you please provide us with anything that's responsive to that request? And they said that they don't possess or maintain a record that's responsive to Mr. Allen's request. And over the course of this appeal, we've gone back multiple times just to make sure that if there is anything, they could potentially, they could give it, we'll review it. But every time we went to them, they said that they didn't have anything that was responsive. And so that's where we are. And that's the matter before you today. This case is similar to the Kim Henderson v. San Juan County case that came before this committee back in 2019. If you recall from the facts of that case, there was a county commissioner in a public meeting who appeared as if he was sending text messages. And a requester submits a grammar request and says, I want those text messages, the text messages that were being sent in that public meeting. San Juan County responds and says that they don't have anything that's responsive. Then on appeal, it came before this committee. And this committee determined that based off of the actions of that commissioner, it appears as if he was sending text messages, it was determined that there likely was, it was reasonable to believe, I believe that was the term that he used, it was reasonable to believe that there were text messages, and then asked San Juan County to provide them. Now this San Juan County case is different than the matter before us today, because at San Juan County, you could see that there was a text message going. The requester wasn't asking for anyone specifically, but they knew that there was a text message at that specific time frame. In this matter, with Utah County and Mark Allen, there hasn't been any evidence provided that Bill Lee sent any text messages to Richard Losey. There hasn't been any proof provided to us that there are any records. There isn't anything on the record where Bill Lee in passing said, hey, I received a couple text messages from Richard Losey earlier, or I sent him a couple text messages. Nothing like that has come forward. In fact, because there hasn't been anything provided to us, it seems to be more consistent with what the commission has told us, that they don't have anything. Now, in no way am I trying to cause a chilling effect on grammar requests for Mr. Allen. In fact, I think this is exactly what he should be doing. If he has any concerns that there is government corruption, the channel, the avenue that he should be taking is through grammar requests. I I think he should do it and continue to send grammar requests, and we have fulfilled requests from him this year. And we have, I believe, a few more in the queue. The issue with this one is we've done our due diligence. We've looked everywhere we can look. We've talked to everyone that we can talk to who would have responsive records. And we don't have anything that's responsive for him at this time. I'll submit on that.
Is there any questions? I have one, or a couple. So in the materials, you mentioned that there's the Utah County database of records. You're
Yeah,
alluding
just
to a
the
database or
records
any of
that we
your
have access to.
databases.
Yeah.
Do you have policy or guidance on how cell phone usage or text messaging? Because there are commissioners, I take it, that have a work phone and a private phone. Does Utah County manage their work issued phone in a different way or a specific way?
You know, I'm not certain the policy offhand. I do know that once a year there is some communication dispersed to the county stating that just because it's on a private device doesn't mean it's outside of the scope of grandma. It is my understanding that Bill Lee does not have multiple phones. He just has his private phone. But I do know that the county will frequently educate its employees that text messages, even on a private device, could be subject to grandma.
Does your policy address how they should maintain on their private device any of the public's business?
I'm not familiar with anything in our policy that sheds light or gives direction on that matter. I do know that this is not a Utah County specific issue. I know that many other entities, just with cell phones coming into existence, it's a hard thing for the county entity to access private devices, and you would understand why that might be an issue.
But is it typical, then, if you got this request for anyone else, you would ask them if they had something on their phone, and then they could say yes, and they would give you the phone and you would download it? And does that happen, or?
So it hasn't happened since I've been here. I've been with Utah County for a year and a half. That hasn't happened. I believe Mark Allen is the second that's asked for cell phone records. I know that the person previous to me they did ask for cell phone records, and the person did provide records.
So there have been some cases in which you did provide records because you could find them. That's what I'm trying to get at.
Yeah, we will reach out to them. We'll ask them if they have records, please provide them. And it is my understanding that we, at least on one occasion, someone's provided it. But like with, for example, my work computer, you know, if there was something that someone believed was on my computer, they could just take my computer. It's not mine. And so I would just have it happen. But when it comes to private devices, it's different. You know, they can't come and take that cell phone. They can't go to their house and take their desktop sitting on in their study.
Quite frequently, if you don't mind.
Sure.
If someone does want records from an individual or regarding an individual in the county, we will take that to our IT department and have an administrator search the device for what we need. But then quite frequently, we will also ask the individual, are you aware of anything that would be responsive to this request as well? Because of course, IT can only search, the best that they can, but the individual that is more of the subject of the record may kind of know, oh, yeah, that's not even going to be under that search term, that's going to be under this. And quite frequently, we've never had a problem with a county employee not wanting to give records. I mean, that I'm aware of, and we've done this for about 2 years. We're probably about 1,200 requests or something like that. I don't know, but so it's just not a common practice for us to have issues where county employees say no. I've never seen it happen. We have had a deputy that gave cell phone records.
That's right.
Someone wanted a deputy's cell phone records during an incident, and we asked him for those, and he provided those. The party wanted to see a lot of the calls. So again, we are always happy to reach out and to help assist, and this is what we need. If you get them, we'll review them, or we'll redact them for you, that kind of thing.
Ask a question. Go ahead.
No, go ahead.
So in this particular case, did you ask Commissioner Lee about what was on his phone? Were there messages related to this? What was his response?
So
We
we,
first went to Robert Baxter though, and we checked to see, does the county maintain that cell phone?
yeah, we looked to see if the county would have those. It was determined no. Then we reached out to his office, funneling our question through his senior policy advisor. And it just kind of bounced through him. But the answer was the same every time.
Then he said no.
He said that there was nothing that was responsive to the request.
Do you know if the other two commissioners have private phones, or, I mean, does the county have, do any of the commissioners have phones that are paid for by the county? Or are they all private?
I believe they're all private.
I think so. And the two other commissioners, one came in just earlier this
Right.
year and one came in a couple months ago, or a month ago. So I'm not certain.
And the county, even though they're county commissioners, the county doesn't provide them this is interesting. Yeah,
The private, yeah, I don't know. I don't know how common a practice that is.
Yeah.
I don't know.
because they're elected.
Any other questions for Mr. Beck? No questions? Mr. Allen, we're to you for 5 minutes to summarize.
Thank you. I first have to say Laura Mendoza has been very, very ethical in trying to perform her job. You've cut right to the heart of the chase. The issue is if we have an unethical actor, and I'm not prescribing that that's the case, but history has shown me that when somebody's job might be on the line, they may say, I don't have any responsive records. You can't touch my cell phone. So I think Adam's highlighted that. The problem here is the county should have a process by which public records are not commingled with private stuff on a private device. Utah County is 10 years behind this times. So is most of the state of Utah. But people in high places that are trying to demonstrate that they're ethical carry 2 devices. You want to audit it? Here you go. Come and get it anytime you want. I've got nothing to hide. Now, Adam, in fairness to your county attorney, you may have not seen the exhibit that I produced. And I don't know if Rebecca can highlight that, but I've got a record, a responsive record. Private citizen sent me the communication with Billy on his private cell phone regarding Bridal Falls. Class B misdemeanor. I'm asking for an audit. John Dougal, top down. Now let's create best prescribed practices for Utah. This is a landmark case. This is probably the most important case you've heard in the last 10 years. Let's don't narrow it down to, is there one just between this one individual? I've already demonstrated by the exhibit that a Class B misdemeanor has been potentially committed by Commissioner Bill Lee. And I don't say that lightly. He knows where I live. Because by grandma, I have to submit my personal address. Here's where Mark Powell lives. The issue really is we've got a systemic problem and processes that haven't caught up with technology. trust but verify, right? So Adam, I'm appreciative you and Laura went multiple times to the commissioner. This is not your problem. I'm not attacking you. I appreciate you being here because you opened up the Pandora's box for discussion and resolution, not just with Utah County, but statewide. We're the best practices statewide for managing text messages. They've acknowledged that they don't procure or manage or let alone classify records because they don't basically have access. That's what this is about, access. Would Bill Lee lose his position as a commissioner if demonstrated that he's now exchanged text messages regarding Bridal Falls? Oh, I misplaced that or whatever. Oh, I lost my phone or whatever. I think state security, county security is an issue here. Cyber spies hijacked JBS, right? Meat producer held their IP hostage. Well, what happens if Bill Lee loses his cell phone and we can't shut it down? And every meeting he's been to, every connection he's had in the last 4 years is now falls in the wrong hands. Is that far-fetched? I don't think so. Are we thinking about that? No, but we should be. There's a lot at stake here, and the allowance of a personal cell phone commingled county IP. When Bill Lee goes out of office, they should say, okay, turn in, when a law enforcement goes out, said, turn in your badge. Your regular secure employee, turn in your Honeywell card. Well, the same should hold true in elected officials. Thanks for your service. Here's your golden spoon. Turn in your cell phone. That's county IP. That's where we need to lead on here. Bill Lee shouldn't be able to walk away, or any commissioner for that fact, after being elected with hundreds of millions of dollars worth of contacts in their cell phone, intellectual property in their cell phone, connections in their cell phone, because they were a public servant. And what they created while they were in the public service needs to stay. And we just pass the cell phone to the next elected official. They can maintain continuity in what's going on in the county. So that's really what's at risk here. And Adam, you did a great job in presenting the problem. Now, I hope that the county and those that are listening in will say, let's create a solution. So we've become totally transparent, trust but verified. Poor Laura is inundated with requests from Mark Allen, and I can tell it's not fair to her. She's being asked to produce records from your boss. That's a pretty uncomfortable position for a county recorder to be in. Damn it, I don't have access. Well, produce them. Well, I trust that he said what he said and I don't have any. Well, I've demonstrated by the exhibit that's not factually true. So where do we go from here? I think Adam and his boss need to get with the county recorder and invite the records office and the records ombudsman and John Dougal to dive into this and create a best practice. I'm not here to excoriate Bill Lee, but over the past few years, I've learned that it's really important for me to do records requests of Bill Lee. And I'm 6 months out on some of these. Do not allow this hearing to be focused down to solely one email, which is what the attempt has been, or one text message to Bill Lee's and Richard Losey. That's not the scope of it. The scope of it includes, please provide copy of all incoming and outgoing text messages related to Bridal Falls and public comments. So that may be down their wheelhouse a little bit, but it's really part of what I've submitted to the hearing here. I don't want to come back here in a month because it won't be a month, it'll be 6 months out. There's going to be a lot of county business transacted, a lot of city businesses, a lot of state business transacted between here and then. And Utah County is already, by their own admission, saying we don't have a process. Well, that's the bottom line problem here. We need a process. What's the process to say if you're communicating on a personal device, you got to turn it in each month and we'll download it. We'll do a forensic audit to see if things have been deleted. This is going to be our process forward. To suggest that we can trust elected officials in today's day and age, I wish we could. then we'd all be out of a job, right? What would we be doing here? This is akin to, this is Utah County versions of Hillary Clinton hiding her BlackBerry. Nothing short of that. So I'd encourage and admonish, I mean, if you want any state statutes or from other states that are saying, look, and they don't contest that a text message is not potentially a public record. But poor Laura, she cannot classify the records because she hasn't even seen them. There should be a 6-year retention. The question I'd ask the Utah County is, do you have any cell records from Commissioner Ainge, Commissioner Ivey, Doug Whitney, Gary Anderson in the last 6 years? Have you maintained one of those records? I know the answer, sadly. How much IP have we let walk? But it need not be so. I believe Utah County has some very ethical actors, period. I've had cities in Utah County turn around grandmas within 24 hours. I've had them provide records that have been left on voice messages. I want to trust in the process. But because I see flaws, i.e. actually a process that is totally absent, I had to speak up. How much government business transacts on a text message? Probably more than we wish that we knew. But we got to know. Context is everything. In my experience, one email that had been hidden from evidence totally changed the narrative. Grandma's that important. Lives depend upon grandma. Public trust depends upon grandma. And this is a landmark opportunity to say, you know, you're right, we blew it. Restitution, I don't know what that looks like, but I do know what reformation looks like, and it falls within your purview to order such. I wish from the top down, the governor said no more personal devices commingling government, period. Any elected official, here's your government phone, period. An ethical recorder can come in and just say, I need your cell phone whenever. We've got a database, we've got things in context, continuity. No, following breadcrumb trails through text messages or emails is not for the faint of heart. But in so doing, over the past decade, I've found upwards of 35 of our trusted elected officials were upside down and inside out. And they're covering their own ass, excuse the French. So I don't believe that we can just say, hey, I trust you. Do you have anything? No, I don't. We need to trust but verify. So this is about a verification process. And a sustaining vote of my appeal would launch Utah in the 21st century. A denial of this request will set us back into the dark ages. And I appreciate transparency. I appreciate the process. I've been able, and this wasn't my trajectory 10 years ago, but we've been able to save Bridal Veil Falls, we've been able to save American Fort Canyon, been able to save an equestrian center. I've been able to save my own backside. I've been able to find out who are the ethical leaders. I've also sadly found that some of them need checks and balances. And I just happen to be the checks and balances right now in Utah County, but I don't want to be the guy doing it for long. So sustaining my appeal and asking the governor for an audit, I think it's necessary. And I don't suggest that lightly. Has there been misconduct? I've demonstrated by the email that you have. I don't think Adam's seen it. Class B misdemeanor potentially. What would that mean to Commissioner Lee? He's been hiding information. So with that, I just say in closing, I appreciate the ethics that I do see in Utah County. There are people down there trying to turn the Titanic. And there have been people that have been tossed off the boat. The problem is we toss them off the boat, and before the boat passes, they climb back on the boat. We've got that in multiple disciplines throughout our state. We've got unethical social workers, we've got unethical attorneys, we've got unethical judges. They're in the minority, but it only takes one. So hypothetically, in closing, this question to the commission and to Adam, your peers, those that may be listening. If you've got an ethical actor who understands that they're riding on the boat with unethical actors, bottom line is they don't turn them in. They fear retaliation. Elected officials in Utah County don't dare bring this out against Bill Lee. Why? He controls the purse strings. There's a problem. Commissioner Bill Lee was the chief administrative officer when I did my Graham appeal. He disregarded it. We got a process problem. This shouldn't have come this far up the ladder, but it has, and maybe there's a reason for it. But I'd encourage you to give thought to the big picture. This is not a narrow issue. This is our processes in place in Utah County to procure and secure records. The answer is no. They've already, by their own minutes, noted that. There's a problem. It's not Adam's problem. It's not Laura's problem. It's bigger than them. It's bigger than David Levitt. This rides up to the top. This should go up to the top. John Dougal, how are we going to do things in Utah? Are we going to trust and not verify? This is about a verification process. And our future, our kids' future depends upon it. It only takes one bad actor to turn the trim tab of the boat and steer it off course. This provides protective measures. This provides a separation of personal commingling of kids, grandkids, and cat pictures with official government records that you and I, it's requisite we be able to look into those. Ideally, we could let grandma go away and just have a process to where all of this stuff comes in and converges, and here's our database. Any citizen can type in and query. It shouldn't be 6 months out. How much business has transpired in the last 6 months on personal cell devices in Utah County, in the state of Utah? I don't know. You watch any legislative hearing? What's going on? So I think that's where it's at, and I really appreciate Adam coming and Laura coming. They've been really trying hard, but their hands are tied. The process is broken, and it's time to put a tourniquet on what's broken, and then say, how do we fix it? So again, this is I believe the outcome of this will be a landmark decision, probably the most important one that you've made. 96% of population that has a smartphone use it to communicate or create records. In the case of elected officials, these are records. No ifs, ands, or buts about it. And Utah County is behind the times. They need to invest some money to create a process. And I think that given that the commissioner is in the middle of this, I think he needs to be arm's length. John Dougal, State Records, Rosemary. Think of what this means to the media and the press. If we can obfuscate, if we can say there's no records here, there's no text messages, think how it will stymie the sunshine laws. That's why I was here 5 years ago. The county commissioners tried to say, we've just got one point of contact, and then behind it, it's the great Oswald. You don't know what's going on. You don't know who's doing what to whom or what, or saying what to when. Who's doing the deals? We don't know. So that was a landmark case, and I applaud the records committee hearing outcome last time. And I look forward to your recommendations forward. It's not a Utah County issue, as Adam has indicated. This is bigger than that. We all know it. It's the elephant in the room. We can do better, and we must. Future generations require such. With that, I rest.
Just a few things. Mr. Allen spent a bit of time there talking about some policies that could be put in place statewide ideas that could be helpful to help improve the integrity of the grandma world. These are legislative questions, and these are not things that we need to be looking at today. Today, we're looking at this specific grandma request that he has appealed. Again, Mr. Allen was saying that his request is broader than I have portrayed it. What I'm saying is he sent in a lot of requests. And this was the one, after we broke it down and laid out how we were going to move forward with fulfilling his request, this was the one that he chose to appeal. He didn't appeal the others. Then he mentioned about some evidence of a text message that Bill Lee sent to McDougal or something.
This is private citizen.
Oh, okay, a private citizen. That's not what we're talking about here. We're talking specifically about text messages, telephonic communications between Bill Lee and Richard Losey. So it's my understanding that still to this point, we don't have any proof that there were ever any text messages between Bill Lee and Richard Losey. And so it is my request to this committee to make a determination that it is reasonable to believe that there are not responsive records to Mr. Allen's request to deny his appeal. I'll spit on that.
Thank you. Any questions for the committee? No questions, then we'll move to deliberation. Start.
So I want to start by addressing this one thing. This committee's responsibility is to deal with the access of records for fees in grandma requests. We don't set policy and we don't tell government agencies how they should administer their records management system. That's unfortunate. The state archives does have a system in place where they train and try to give best practices to the governmental entities, trying to help educate them and learn how to do that appropriately. When a request comes to us, we are then tied to dealing with the access to the record and the fees. To the government agency, I would say, grandma says that in 102.1a that the public has a right of access to the public's business, and in tool 113 it says that we can't use the physical form, electronic or otherwise, to deny or unreasonably provide that access. And so I think we as government, I work in local government, the electronic data is a record according to the records definition, regardless of physical form or characteristic. So I would highly encourage you to find a way to address, if he's not using any other device but that cell phone to communicate, it leads me to believe the public's business is taking place on his device, and that those records do need to be maintained. The county has a responsibility to maintain those in some way. So I totally believe that you guys have looked, that you've asked, that you've been told, and I believe that you don't maintain it. But I can understand Mr. Allen's argument that, you know, it would be easier for me to believe it if he was using two devices, right? So, but I don't think that we can force you to provide access to a record that you don't maintain at this point. Like, I don't know how you're supposed to get that record. I don't, but I do think that if you take the intent of the legislative intent of grandma, you know, government has a responsibility to to provide the public with access to the public's business. And so I think, you know, we maybe can take this experience and move forward and try and find a way to do that, right? And I think every governmental entity should take this experience and find a way to do that. We, as the records committee, we are not the legislators. We can't tell a governmental entity what their process should look like. So I'm just trying to open up some discussion among the members and see if we can get this going. So,
Well, I want to ask our attorney, do we have the authority to order them to request the phone?
To request the phone? Oh, boy. We had one case that was Cedar Hills, and there were emails that took place with city council members. And the order simply said that they should try to produce the records. But we don't have like court authority to, you know, do this or contempt of court.
But we could lend them support by simply saying to uphold the appeal and say, tell them to go back and ask Bill Lee about the use of his phone. We could have him do that. We just can't.
Suggest.
I mean, we don't have subpoena power, right? So it's
Right.
like, we can't get the phone.
Yeah, you don't have the, you know, holding contempt of court, and we're not in court.
Yeah.
And that's the hard part of, and we've done archives training on this. Matter of fact, it's an issue that is percolating throughout the country. Obviously, you have text message. I mean, there's even a question we started out with, was a text message considered a record? I don't know if archives in some cases even has a retention schedule for text messages.
Yeah.
It's definitely not specific for that.
right, it doesn't list testimony, but it is an electronic communication, so I would argue that it's reproducible.
Yeah, if you can reproduce it, and so it's
Can
it's a
we-
tough question. Do they have control over it? If they say no, what's their recourse? I mean, how do they comply with one and then?
Can we ask for a notarized statement that there is nothing on his phone that would relate to a?
I think they say that in their materials, though.
Yeah.
That have been submitted to the committees,
I think
that
I
they've made
did
every
read
effort.
somewhere in the statute about an affidavit to be submitted, but
But in the materials that they submitted to the committee, it says that they've made every effort.
right, I agree.
To comply with the request.
Oh, no, not from them, from him,
Oh.
from Bill Lee.
Now, of course, if this was, say, appealed to district court,
Maybe
district
that's
court judge would have a whole lot other things they could do. Because then it would be an evidentiary type thing.
So it would be better for us to deny, he goes to third district court.
I'll just simply say,
Yeah.
district court has a whole lot more authority. than we do.
Okay, I will put better, yeah.
I think
keep it simple.
if I could paraphrase what I think Nancy was saying, I totally agree with it.
Yes, me too.
There should have been, but there wasn't. There should be some recourse here. There should be something that mandates that government entities of any form are aware of what their elected officials are doing on their electronic devices.
And that's what the petitioner is saying.
Yeah.
But there is.
Yeah, but there
I
should be.
totally agree
You know,
that it's,
and I,
that
you know,
it's
we can't order
wide.
them to say, go to Commissioner Lee, fork over your phone, let's check it out ourselves. We can't do that. They've asked him if there was evidence. He says there's not. We're not authorized to question whether he's right or wrong or order him to prove it.
Right.
But it could be done in a district court. But the whole transparency thing is interesting. So I pulled up something, one of my favorite documents, HP 477. Which I was intimately involved with, because at that point, I actually testified as the president of SPJ about that. And it was sponsored by John Dougal.
Yes, it was.
And one of the things that the state legislature tried to do in 2011 was eliminate the possibility of having electronic text messages or cell phones open to the public to find out what was going on. And that thing was passed by the legislature, and the media came down on it, and it went down in flames, and it was revoked in 3 or 4 days. It got the state of Utah incredibly negative publicity. I picked up the national honor for the small chapter of the year because it gave the black hole to the Utah legislature. I'm not trying to make fun of the legislature, but the point is, this has been a problem for 10 years. And I think everybody who's involved with records on a government level is aware of what went on there. And the problem still exists. So I understand the frustration of the petitioner. I also understand the response, in my opinion, have done all they could to see whether, they've gone to the source of the request. He says, I don't have anything to give you. There's nothing else they can do. But there should be some other policy in place. And I really think at the bottom line, that's really what the petitioner would like to see here, is that this sets the precedent for governments to get a little more serious about it. I have no idea whether the cities have issued cell phones. I think the legislature does have issued cell phones. I'm not positive of that. Most legislators have 2 cell phones that I'm aware of. So I'm assuming that the state pays for one of those cell phones. But I don't think there's anything that we can do other than what you suggest, that what should happen and what is happening isn't the same thing.
Right.
And it's a footnote to that the state records committee actually voted to suggest the legislature not to pass HB 477.
I'm sure you do.
Led by Betsy Ross. It's like this is going to take transparency out from.
And her name was Betsy Ross, believe it or not. That's true.
Yeah.
True story. So I agree with what you're saying there. I mean,
Right, I mean,
But I don't know,
it's
we can-
easy to see both sides of the coin,
Yeah,
right?
absolutely.
I mean, and I firmly believe that there should be processes in place. I can't argue against that, right? There should be, and we should work towards that, and we should work towards it faster than 10 years. I guess that's what it's been, 10 years
so
now,
this is this thing.
and still local government. Now, in some, I represent political subdivisions on this committee, or however you want to say that. And cost of software to be able to do some of those things to little communities that might have 500 people, and you bet their guy that's carrying his cell phone is doing public business on his cell phone, but the cost for them to have the resources necessary to be able to maintain all of that in a database becomes just too hard for them. But, and so I don't know what the answer is, because you have to look at it from all aspects of government. Yeah, the state might be able to afford a multi-million-dollar software to help them do that, but smaller communities, rural communities are going to have a real problem with that. And they may be some of the, ones that are having particular problems, right? So I get it. We have to there has to be a solution. And I'm sorry that it can't be the State Records Committee that says what that solution should be, right? So I believe the county did their due diligence. I think you went to the source, you asked. I think it's clear that you did. It's clear that you were told they didn't exist. But Utah County should be a county that's leading the way, right? One of the larger counties in the state, and we need to do better, right? And so whatever we move to do, we need to do better. That is fact. You are right. We need to do better. But in this case, I agree with Mr. Beck. We have to go back to this request, and we have to go back to the fact that the county did its due diligence. They did ask. They were told no. They've done everything that they can do, and didn't come up with anything. And so I would make a motion to deny the appeal.
On the basis that they do not possess those.
Sorry, yeah, on the basis that they don't possess or maintain the record. Yes, thank you.
We have a motion by Nancy to deny the request. Is there a second or discussion to the motion?
Yeah, I'll second it.
Second by Marie. I suggest we take a roll call vote.
Well, let's
Any discussion?
You want some?
Yeah.
Oh, yeah.
Sure,
Sorry.
let's do it.
So I think you're absolutely right. I'm going to support the motion because I don't think we have a choice. We
Right.
can't order them to do anything differently than what they've done. They've done everything that they could. If there's a roadblock, it's not here. Okay, but that doesn't mean that it should be considered a pass for anybody to keep their information on their cell phones, thinking that they don't ever have to turn it in.
I so agree.
So I'm unhappy about the fact that we don't have a conclusion other than this one.
Yes,
And
I
can
so
we
agree.
be sure and put that in the order?
I don't think it must be-
That's what I'm asking. What kind of commentary would you like to have me in there? Have put in there?
Does that commentary need to be part of the motion? Is that,
Well, I do what you guys want me to do, so.
I would love some commentary in there that that processes need to be developed to maintain a record of the public's business. And when the public's business is done on a personal device, that record needs to be maintained by the governmental entity. And that we should be moving forward quickly with that kind of a resolution.
That's really good. That
Well,
record
I'd
is
like to see
subject
a
to,
real
the
space
subject
on
record is subject to
Yeah.
the public.
That'd be
Yeah,
great.
well said. Well, and there's got to be something, I mean, what you said is really good in reinforcing what the state should do. But I would like some commentary more on there that elected officials must understand that if they are conducting, if they are texting or contacting people on their personal phone, that they need to give access of that electronic information to the state, that's part of being a public servant.
So just make sure I got this right. So, for example, elected officials might have a higher level of transparency needed because they are elected officials.
Right.
Absolutely.
If they're doing government work in other capacity as an elected official
Can
on
we
a
say
private
elected
device.
or appointed? I think
Appointed or appointed,
I
yeah.
think appointed officials have that responsibility as well.
We could do that, sure.
One thing about going back to 477, one of the things that we heard from the legislature back then, this is just an FYI thing, is they didn't want all of their personal and private emails to be available to the media or anyone else, because, you know, as an example, if someone got a message from their spouse that said, on your way home, buy milk, they were afraid the media would say, oh, they're supporting the Utah Dairy Commission. And that's not what it's all about. You're laughing at that, but that's just how weird it got up there 11, 10 years ago.
Well, and it's actually another step from that. It's not so much the public knowing that, because chances are good if they go through and review them, they're going to go back and say record does not mean a personal note. So it wouldn't be for the public. But what we hear, because I mean, this is a discussion in the archives and everything. They don't want to have someone else in the government looking through at all their personal stuff, which is why you do have a lot of places that have, do you have your two phones? That you have two phones, you do your government work on one, you do your personal on the other. And that is becoming more common practice throughout the state.
Let's see.
So
It's not a
because
record, don't worry about it.
it's so hard, how do you know, differentiate between the two? And they don't want someone looking through their personal stuff, because those are not records.
Right.
May not get
And
out to
we,
the public,
and no
but
one's gonna say that you support the Dairy Commission because you buy milk. That's, nobody's gonna write that.
you would think.
Well,
But we have this very clear demarcation about what is private and public and what's the third one? Anyway,
Control.
and controlled, that can be applied to those messages. And it's just a matter of transparency. The other question I wanted to ask, you earlier said that now was the time to relay what legislative changes might need to be done. And I wonder if this is an issue to put on our list to say, we need to think about more clearly about personal cell phones and how they're being used and text as
I feel like,
part of that discussion.
sorry. to interrupt you. I feel like grandma, it's pretty clear. The public has a right to know the public's business. That's number one in the legislative intent. The public's right to access the public's business. I mean, I don't know how more clear that.
So you're using
Well,
part of the
but it
statute.
can be, it
Yeah.
can specifically address this situation and say, public and appointed, to be asked whether or not you've got anything relative is not enough.
Right.
You have to show that you don't have anything.
Yeah.
And that's what I'm thinking in terms of
Yeah.
making it clear.
we're picking on, we aren't necessarily picking on you. We know this is a problem everywhere, right?
No,
I,
agree. Yeah, I just think you expressed it very well, and I think the intent is, we wish we could do more, but we can't. That's why I support the motion when we get to that point, but we're not happy about the fact that there's nothing more that can be done by this commission.
right.
Maybe we can say that, it may be considered a record, if, done in the personal capacity of an elected official, elected or appointed official, but the record is not controlled by the governmental entity, and therefore you can't order release of something they don't have.
It's just so, this reinforces to me that we have two employees here that have two phones. And the commissioners of Utah County are using their own personal phones still?
Well, that might be true in Salt Lake County or Davis
Yeah,
County, I
might
don't
be,
know.
yeah.
Oh, it might be true in a lot of places, and
Yeah.
it just won't say who. Yeah.
So employees have to do it, but elected officials can decide. And that's the kind of stuff that you might want to think about some language.
Well, and then you go to the point over here that you have like a small city, 500 people.
Yeah.
Cell phone plan for every single person is like a 500-person city council, and they can't afford that. And so it's a great
That's why
question.
it's hard. That's why
Yeah.
it's so hard, right?
I think cost of bears ears being given up.
Yeah.
Small town, right?
Yeah,
Communications,
exactly.
cell, what's the cost, really?
So those are all legislative things.
Right, they're
Maybe
legislative.
at some point the legislators with their cell phones will figure it out. But I'm sorry, I'm legal counsel, I'll step back. Again, what is in, again, 103.22A, that is prepared, owned, received, or retained by a government entity or public subdivision. That's part of your definition of the record. So,
Government entity encompasses commissions,
yes.
commissioners,
Oh, yeah.
Yes,
individuals.
absolutely. Well, commissioners are part of a government entity. They are not a government entity, but they are commissioners for a governmental entity, which Utah County is.
They're in the problem.
They're part of Utah County.
I think that's why Nancy, I think it was you brought up that, the 102.
The public business. Commissioners obviously do.
They
public
clearly
business.
do the public's business.
Yeah.
King County Records has addressed this. They suggest a 6-year retention, similar to emails. This might be helpful as you do deliberations for subsequent issues. I'd like to let you have access to this.
Well, I think that what the state archives has done is created a series number that's called electronic, or help me, communications. It doesn't matter what form it's in, and it has 6 or 7 year retention. 7, isn't it?
7 for states,
Right.
it's 4 for.
So it's already there.
Yeah.
So they just need to be applying it properly. So.
And those are the things, I don't know how long you guys in your retention keep it, but those are the things historians need 50 years and forward to write the history of this period. I've got to find out what people were talking about on the. communicating about it.
There are multiple retention schedules for correspondence. There's one that's
No, that's what it's
transitory,
called.
one that's transitory, one that's administrative, and that one has 2 different ones for state and local. And then one that's executive, which is for the
Permanent.
historical stuff.
Can I ask Rebecca one question?
They're in deliberation. But, ask me a
Yeah.
question?
Sure.
Let him ask, you can decide whether or not.
You don't have to answer it, but.
I would prefer we finish the business at hand and then
Maybe we
Oh,
can
okay.
shortly recess, might be a good
stay
time
after.
to.
It's germane to your deliberations.
Go ahead.
Do you retain any text messages from any former county commissioner from Utah County?
Does the archives maintain any?
You've got the process, they're all set up. Do you retain even one cell message over the last decade from any former county commissioners?
I am not certain. I'm more familiar with the process of directors from state government leaving. So I participated in that process, but with commissioners, I haven't participated in that one. I don't work with local government, or didn't.
But it's not the state's responsibility to keep that record. It's the
Local
governmental entity's responsibility to keep that record.
And to manage the record.
Yeah, so they make a recommendation about what that definition and retention should be. And then the governmental entity should look at that recommendation and either accept that recommendation or adopt an ordinance with a different retention.
So what role do they play in keeping records for 75 years? that are
Well, the
supposed to be true?
historical ones eventually go to the.
So that's where text messages could be
Would
historical.
eventually, they might, yeah,
Yeah.
right, at some point,
So
they might end
that's
up
where
there.
we're
The
missing that.
permanent communication correspondence would end up eventually at the archives, yes.
Yeah, but we don't
The
know if it's a record
transitory-
unless the records officers had access
Yes.
to classify it.
Correct.
And that's a big cap too.
Yeah.
Thank you for
Good point. Thank you.
allowing.
Any other comments, discussion to the motion?
Want to hear the motion again? We have a motion by Nancy, seconded by Marie, to deny the appeal on the basis that the entity does not possess or maintain the record.
And I know all the other stuff that was.
Yeah.
And
Get all that
yeah,
other good
Just
stuff.
so we
Got
get all that
notes
other
for
good
Paul.
stuff
Throwing
in
the
there.
other stuff. Because, yeah, why not? It's about time we have a good decision on this.
Yeah, it is.
Right, right, I totally agree. And just saying we deny the appeal doesn't help. Because that's not our intent.
Okay, we have a motion and a second. Lots of great discussion. We'll take a roll call vote, starting with Mark.
Aye.
Nancy,
Aye.
Marie,
Aye.
Tom,
Hi.
and I vote aye. We did without three. So
We made motions today.
I know, don't tell her we know
We
how.
won't.
So the parties, the order will be issued in 7 days, and you have 30 days.
7 business days.
7 business days and 30 days from the date the order is issued to appeal in district court.
And we will say there will be some substance to this order.
Thank you, because I don't want to be back in a month, but I've got another appeal for broader scope. So
It's an issue, again, archives has been training on. Discussed often. So the order will, talk about the parameters of that.
thank you. Time.
Thank you.
Thank you both for being here.
Thank you.
Three. We've covered all of our business. Is that everything? All the items on the agenda. Does anyone have anything else?
Did you want to go back to talk about the vacancy?
Yeah.
Number
You
7.
asked me to remind you about changing,
Criteria or-
going back to discussion about the vacancy on the committee and changing the role or.
So what I heard from
Sorry.
the committee was one suggestion to expand the number of committee members.
Right.
And another to look at the language that describes the positions.
Yeah, like categories.
And see if those need to be brought.
I don't know if we need more, but I'm not against it. But I like expanding the categories so that it's easier to.
So it seems like that we don't need to expand the definition of Mark's position, Nancy's position, of course, mine can't. Citizen member,
They're always an
press,
immediate
those
Yeah.
seem
We can find people that actually want to do it.
right. It's that vacant position. Do we have one that's
Well, and I'm
larger than life?
And I'm concerned, since this is June, if Tricia really is off in September, and we're not sure when Cindy's position determined, I mean, you can extend, it can happen. But there needs to be, they need to get with it with some appointments. They really do. So if we have to change the criteria to get people who are willing to serve, then we probably have to change the criteria or consider doing that. But it really,
Tom, for that one position, the citizen member
yeah,
is the easy one.
yeah, well, it's easy, but it's easier.
And I would suggest we don't change that.
No, that's probably a good
Oh,
position.
yeah.
We want
Keep
citizen.
that one. Oh, yes, absolutely.
If it's the other one that's, what was it, technology and.
Would have
Database.
been a nice one to have today for our first one.
Yes, it would.
Or the one that
That's what I was thinking.
University of
Database
Utah.
expert.
need a
Yeah.
database person, tell me.
I don't have an action item on the agenda for this discussion, so you
can't do
can
it.
talk, but.
There's no motion.
Well, I think I mean, it's the archives place to manage the committee to come back with a recommendation. What that language would look like for that one position. I think I'm hearing from the committee, don't mess with a citizen member. Don't mess with the press, don't mess with local government.
Do you need
private
to,
sector.
can the committee make that change, or does that have to go before? the Senate?
Legislature, it would have to go to the legislature.
So you have
It's defined by statute.
Yeah. Yeah, so what I was saying, Tom, is like, we're in a place right now with just our department changing, the archives falls in, they're looking at code. And it's a good opportunity to just make those suggestions, because we have that here right now. Through this session, if we can.
Yeah, well, but they're not gonna meet again, Bill.
The meeting interim.
Oh, okay, so you can do interim, because you may be out another person, in September, and we can't do it without these 5.
Well, I think for the next meeting, we need to put on the agenda, we'll report back.
Okay.
Well, she's leaving it on this.
All right.
So
Well,
was that a
since-
citizen person nominated or anything?
Okay.
So if you know a
I
citizen.
recommended someone.
Did you?
Yes. Someone we all know
So I
really
suppose
well.
starting October,
Who's that?
don't always make sure you have your second Thursday. free.
Oh, you should use the citizen. Wow, that would actually be a good one. Yeah, I know.
So,
Cindy actually writes for me now, so among other things. Wow. That's just one of her part-time things. She's not a press person. But she really missed being on the committee. She'd like to.
Yeah, I think it'd be a really good option.
Okay, any other discussion?
This was fun.
This actually was.
We need a motion so we can turn off the recording.
This is fun. Move that we adjourn.
Yeah, second.
So we have a motion to adjourn and a second. All in favor, say aye.
Aye.
Aye. Rebecca, stop recording.